I know, yeah. What we need is another half table.
Oh, yeah.
Another table.
It is pretty rare that we have.
I know.
It's a start.
I can get another table and just put it sideways here. I can pull one from another room if you want. Or it could be a long day.
I mean, I'm here.
You sure?
All right, let's just see how it goes.
You got my seat.
I can have your seat.
And everything that entails.
Council for the day.
Definitely not.
Yes. Good morning, we'll call the meeting to order. And first item of business would be the agenda. Are there any further amendments other than the one you? I think that got printed, the one that was on the table.
Yes, although I'm not sure that I managed to get that version to the website. I just
Oh.
crashed on me last week, so she's, which is the first case that was on for the agenda, has been tabled until July.
And what's the name of that case?
Sheik versus
Okay.
the Portland Gastroenterology, PA 3401.
So the agenda that's here does not contain that. So the one we're voting on is the one that's here in the room. And we contain a motion to adopt the agenda.
Set.
Any discussion? Being none, if you are in agreement, you will vote yes. And the commission's remote participation policy requires the commissioners to indicate their votes both visually and audibly. Commissioner David?
Yes.
Commissioner Ryan? Yes. Commissioner Walker?
Yes.
Commissioner Douglas?
Yes.
Commissioner Sanders? Yes.
So, good morning. My name is Ed David. On behalf of my fellow commissioners, I welcome you to this meeting of the Maine Human Rights Commission. Before we proceed with the business of today, I'm asking each of you who may have an electronic device, cell phone, pages, etc., to ensure that they are silenced now. We have additional agendas, including the consent agenda, available in the back of the room and online. The consent agenda is a listing of cases in which no written arguments were made to the commission in the allotted time. The commission will vote on those cases and they will not be considered today. Remaining cases on the agenda that we just adopted are coming before the commission to determine if reasonable grounds exist to believe that unlawful discrimination has occurred. The commissioners have received and reviewed investigators' reports and any written submissions submitted within the allotted time. No new information or any written materials will be accepted today. Cases will be called in order on the accepted agenda. As I call each case, the party who has submitted a written argument will be called to the podium or recognized online to provide the most relevant arguments to the case. The time is limited to 10 minutes. Time may be reserved to rebut opposing arguments, but the time limit of a total of 10 minutes may not be exceeded. Procedural rules of the commission specify that your arguments may address only one, relevant factual errors, two, relevant omissions from the reported facts submitted during the investigation, relevant issues and questions concerning interpretation of the law. The commission allows parties who do not disagree with the investigator's report to rebut comments made by the opposing party. Please be advised that the commissioners may ask questions, and I will ask that you introduce yourself as you are recognized for argument. And with that, the agenda starts with our business meeting, and therefore I would call on Executive Director.
Okay, so first I need a motion to adopt the April 2026 minutes.
Second.
Any discussion? Seeing none, Commissioner David?
Yes.
Commissioner O'Brien?
Yes.
Commissioner Walker?
Yes.
Commissioner Douglas?
Yes.
Commissioner Sanders? Yes. So for reports, no change in personnel, although we are now at what happened?
There can be a story, it's just a TV.
We are experiencing technical difficulties, but the camera is still going, so I think they're just on our end. No change in personnel. We have posted for an investigator, so we're interviewing and trying to hire somebody for that position, starting probably in the next couple of weeks. We will also be hiring for another secretary associate legal since Jillian has been the business manager position. So that's exciting. For compliance, we have 4 cases in active conciliation, 1 unsuccessful conciliation, and 1 dismissal to approve. You all got a memo about E22-036 Mulkern versus Ascension. The respondent has complied with that settlement, and that case is ready for dismissal. Anybody would like to do so?
Yes, I'll move that we dismiss E22, 0363, Mulkern versus Ascension. Second.
Any discussion? Right, seeing none, if you are in agreement, you will vote yes. Commissioner Davis?
Yes.
Commissioner O'Brien?
Yes.
Commissioner Douglas?
Yes.
Commissioner Walker?
Yes.
Commissioner Sanders? Yes. For investigation, we had 62 new complaints with a total of 94 respondents. 22 administrative dismissals, 8 right to sue letters. For predetermination settlements, we had a total of, I think we had in my head, 15. 6 in mediation, 6 private settlement, and 3 that settled while they were being investigated for a total of $310,000 to complainants. 2 withdrawals with no benefits. Litigation, we would ask to take an executive session. And other than the hiring, I have no new business for you today. Any questions about any of that?
Well, the hiring reflects confidence. So we can survive the payments.
The hiring reflects that we actually got our HUD money.
Ah.
It has cleared, it is in our account, and so with that and with those 4 split positions in the general fund, when the budget goes into effect in July, we do have the funds to finally hire
Good.
another investigator. It's very exciting. The investigators are all excited. Workload getting a little intense. Should we be in recess until 8:45?
Yes.
Go try to find.
So we got 7 minutes to.
Hello? Was I disconnected? I was listening in, but I wanted to follow up and see because all of a sudden it went quiet. This is Creanne Jones. Is there anybody still there?
They're on a brief recess until 8:45. I'm not sure if you can hear me.
Okay, I can. Yes, I have a quick question. So my case was this morning for 8:15. Are you able to let me know what because I tried logging. I tried logging on this morning. My case was this morning. Are you, ma'am?
I'm just a counsel on one of the cases. I'm not one of the
Hi, we can
commissioners.
hear whoever is speaking. You are live on, so I don't know, we keep muting you because of that. We will be back in session at 8:45.
Okay.
Session, proceed with the hearing agenda. The first case for hearing is ED 240017, Robert Hendrick versus Northern Maine Community College. The recommendation from our investigator to the commission is that we find that there are no reasonable grounds to believe unlawful discrimination existed, and therefore we will hear first in the order of argument that the respondent.
The complainant.
The complainant, I beg your pardon.
And before we get started, I just want to remind all of the folks on Zoom and in the room today who are presenting that the commission's confidentiality provisions require that we not use the names of anyone who is not a party to the case. Generally, those people or entities have been given pseudonyms in the report, so we would ask that you use those, or you can just use the person's title. Attorney Bauer, you have 10 minutes. Do you want to reserve any of your time?
No, I would like to take the full 10 minutes though for my presentation. Can you all hear me okay?
Yes.
All right.
Whenever you're ready, go ahead.
Thank you very much. Good morning, commission members. My name is David Bauer and I represent Robert Hendrick, the complainant in this matter. This is fundamentally a very straightforward case involving educational discrimination. Title 5.
Pause for just a minute. We're turning the, we could hear you and now we can't, so we're turning the speakers up.
Okay.
I don't know, I think you're pressing instead of pushing. Okay, try now.
Just go ahead and let's see if we can hear you.
All right. How about that? Is that okay?
Better? Okay, great.
Great. Title 5, Section 4553 provides that unlawful discrimination under the Maine Human Rights Act includes unlawful educational discrimination as defined and limited by subchapter 5B, which states in turn at Section 4601 that the opportunity for an individual to participate in a school's educational program without discrimination because of a physical or mental disability is a civil right. And Section 4602 says that it is unlawful educational discrimination to subject a person to discrimination in any academic program or activity on the basis of a mental disability. As you know, when determining whether discrimination has occurred, the MHRC and Maine courts look to related federal law and regulations, notably those promulgated by the EEOC. The relevant federal law here is the Americans with Disabilities Act, or ADA, which defines discrimination to include the failure to make reasonable accommodations for the known mental limitations of an otherwise qualified individual. So, pardon me. So the ADA essentially imposes an affirmative obligation on employers and for the purposes of the Maine Human Rights Act on educational institutions to accommodate otherwise qualified individuals with a disability. Now, the MHRA's definition of physical or mental disability includes, without regard to severity, an intellectual disability. The record in this case clearly demonstrates that the complainant, Mr. Hendrick, has been professionally diagnosed with a specific learning disability that constitutes a disabling condition with impairment of the mental functions of both reading and writing, both of which are considered major life activities under the ADA and relevant case law. Since he is a qualified disabled individual under the ADA, he is also a qualified individual under the MHRA. Now, Mr. Hendrick presented the appropriate documentation of his learning disability to NMCC with his initial application for admission to the school on January 7th, 2022, and he submitted it again on February 25th. The reasonable accommodation that he requested was primarily up to 50% extra time for taking timed tests and quizzes. His request was never granted. To put it simply, bureaucratic incompetence and bungling on the part of NMCC led to their violating the law. As I mentioned, Mr. Hendrick presented the documentation of his learning disability to NMCC on 2 separate occasions. On the very same day that he submitted it the second time, February 25th, he also submitted the exact same documentation to Southern Maine Community College in connection with a test he was scheduled to take at SMCC's Maine Fire Service Institute division. It's important, I think, for you to consider and understand exactly how SMCC responded to this request.
Attorney Bauer, we have given SMCC a pseudonym in the report. Please use that. We're not a party to this case.
I apologize. I had in my mind individuals. I wasn't thinking about institutions.
Sure.
He muted himself.
Oh, you muted yourself. You're muted. There you go.
I apologize. I was thinking in terms of individuals, not in terms of institutions. So I'll try to avoid that. Anyway, that provides a very stark contrast with the treatment Mr. Hendrick received from the respondent here, NMCC. The record shows that the director of disability services of that other school to which he submitted his documentation, within just a few days, informed Mr. Hendrick that his request for an accommodation of his learning disability had been approved, attaching an internal memo noting that he had submitted the appropriate documentation and stating that this disability has been verified, quote, this disability has been verified and found to meet the criteria set forth in the Americans with Disabilities Act, unquote. Remember, the exact same documentation was submitted to the two different schools. One school responded quickly and professionally to what was, after all, a very simple request. The other school, the respondent in this case, responded with what can best be described as a bureaucratic runaround. For example, NMCC's Disability Services Coordinator sent an email to Mr. Hendrick on March 15th, 2022, in which she acknowledged receipt of the paperwork concerning his disabilities, but still asked if he was, quote, looking for accommodations. This, of course, makes no sense whatsoever. Why else would he have submitted the documentation? Now, changing gears a little bit here, I'd also like to draw your attention to the fact that the entire legal analysis contained in the investigator's report in this case is fundamentally flawed. The report analyzes the case as though it were a public accommodation case under subchapter 5 of the MHRA. It is not. It is an educational opportunity discrimination case under subchapter 5B, as I've already explained. The author of the investigator's report, who incidentally is not the same individual who conducted the issues and resolution conference in this matter, apparently did not understand that the MHRA uses the word accommodation in two entirely different ways. Public accommodation is one thing, and reasonable accommodation is something else entirely. The question here is not whether NMCC is a public accommodation to which Mr. Hendrick was denied physical access because of his disability. The question is whether NMCC was legally required to grant his request for a reasonable accommodation of his documented learning disability in connection with his education at the school. This is not simply a minor technical error. It is a critical and fatal flaw in the report. This case does not involve whether or not an official academic policy should have been modified to satisfy Mr. Hendrick, as the report's legal analysis would require. And because the legal premise on which it bases its analysis is incorrect, the court cases cited by the report in support of its recommendation are all completely irrelevant and off point. Now, I'm close to wrapping up here. I expect you will hear from counsel for NMCC, who I think will likely make the following points. First, counsel may allege that Mr. Hendrick never submitted a request for an accommodation. I think that is clearly false. The law here is clear that such a request need not employ any magic words or even reference the ADA. It simply has to put the school on notice that a special accommodation has been requested, and I think that test was clearly met here. Council may also make the point that Mr. Hendrick was able to manage to complete the fall semester, but that is irrelevant. His academic performance while enrolled at NMCC cannot be determinative of whether or not the school met its legal obligation to provide him with a reasonable accommodation. And there's no support at all for this theory in the law, rules, or case law. counsel will likely argue that Mr. Hendrick failed to engage in the interactive process required by the law, but that is incorrect. It was NMCC that failed to make a good faith effort to engage in the interactive process. I've already mentioned the email sent to Mr. Hendrick on March 15th by an NMCC employee. Consider also that a senior person at NMCC with a position of relevance here discussed complainant's request for accommodations with him over the telephone on April 26th and clearly learned enough during that conversation to know that Mr. Hendrick was requesting class notes and extra time for testing, and yet emailed him a week later to ask, quote, "Is that correct?" Or the fact that this same individual at the Issues and Resolutions Conference explicitly and clearly admitted that he ended the April 26th telephone conversation by hanging up on Mr. Hendrick. Or the fact that on August 30th, the NMCC Director of Medical Assisting at the time apologized to Mr. Hendrick in writing for the fact that the school did not accommodate his disability. Finally, if counsel makes any reference whatsoever to influenza vaccination,
That is your time, Attorney Bauer.
I have one more paragraph. Is that all
That
right?
is your time. That is your time. Commissioner questions for complainant's attorney? Commissioner Sanchez.
Sure. Good morning, Attorney Bauer. I'm curious about narrative in the investigator's report on page 5. It's the paragraph at the bottom of the page that begins with the word second. In that paragraph, the investigator describes that the dean in this particular case responded to your client's requests on May 2nd, May 4th, and May 9th, encouraging your client to engage in the interactive process. And, I'd like to hear more from you about how that doesn't meet good faith engagement in that interactive process. It also appears that your client did not respond to those emails and requests to engage. That seems like a fatal flaw in your argument, and I wanted to give you an opportunity to respond.
Can you hear me?
Just got very quiet.
Sorry, how about now?
Yes.
Okay. The record shows that Mr. Hendrick made multiple attempts to communicate to some of these people at NMCC. And there were some crossed wires and some emails that were never received and some phone calls that were never answered. And it does get a bit muddy, but he did make a good faith effort. At some point, he kind of gave up on the idea because he had been hung up on, and he assumed, correctly it turns out, that his request had been denied, as was confirmed to him in writing. So I don't think it's a fatal flaw at all, and it may be that the commission would want to hear from Mr. Hendrick directly on this. I'm sure he could be brief and explain his perspective on engaging in the interactive process.
Thank you, Attorney Bauer. You're here as your client's representative, and so there's no opportunity for Mr. Hendrick to address the commission.
Any other commissioner questions for Attorney Bauer? Seeing none, we will to Attorney Huey.
Attorney who?
Thank you.
Melissa Huey.
Thank you. Good morning. My name is Melissa Huey, for those who didn't hear before, and I represent the respondent in this case. I'll be brief because I think the recent questions sort of highlight my position, which is that the facts here demonstrate that the university engaged in good faith in the interactive process, and because the complainant didn't respond, they weren't able to do anything initially. And further, later, when he asked a teacher for assistance, he was provided with additional assistance. So what happens here is he was admitted to the college in early 2022. He sent in 2 doctor's notes regarding his disability, both of which were dated in 1994, which is almost 20 years before. So the Director of Student Support Services wrote him an email on March 15th saying, I received the paperwork concerning your disabilities. Are you looking for accommodations? If so, I will need updated documentation, which is pretty reasonable given that this was almost 20 years ago. We typically look for documentation within the last 3 years. However, she goes on, depending on what you need for assistance, we may be able to put some of that in place without documentation. And then she says, let's keep in touch and let me know as soon as possible what you need. She hears nothing. So then the dean of the college reaches out a little bit later and talks to him on the phone, and then follows up with an email where he says, I believe the examples you provided to me during our phone call included getting class notes and extra time for testing. Is this correct? Always makes sense to confirm something like this in writing. Having confirmation of the accommodations you are looking for will allow us to take next steps. Most specifically, determining if we do or do not need more recent documentation, and if so, what type of documentation and from what provider. So he's reaching out again. He hears absolutely nothing. Then the dean of students writes again and says, did you get my message? Can you reach out to us? And again, they hear nothing. And that is essentially, he starts to participate in his program. Later, he reaches out to a teacher and says that he would, he has some troubles. Could she assist him? She says, absolutely. She hooks him up with a tutor, and he was able to successfully finish the project, the program. So I guess the question here is, what more could the university have done? That's one question. But the bigger question is, what more did the university or the college have an obligation to do? And given that they're reaching out to him, he's not providing information. And then when he finally does provide information, they do give him what he asked for. I think it's pretty clear that there was no disability discrimination in this case. And that's all.
Okay.
I'm not pausing.
Yeah. Good morning, Attorney Huey. Curious
morning.
about at the bottom of page 5, also in the investigator's report, and then you heard a moment ago, complainant's counsel reference this as well. The report identifies a conversation between the complainant and the dean on April 29th. And I'm just curious if you can characterize the nature of that phone call that the parties had. It appears that there's lack of clarity in the record about the degree of what's described as hostility in that phone call. So I'm just curious if you can help the commission out and characterize how that phone call went.
So I think that during the Issues and Resolution Conference, there was testimony from both the dean and the complainant about that. There's no doubt that there was some frustration that was going on. But I don't think that the dean was hostile. I think the dean made it clear that he was there to provide reasonable accommodations if necessary. And that's why he followed up with an email.
Morning, Attorney Huey. Attorney Bauer started his presentation by saying there was a fundamental legal misunderstanding and claims that the investigator was applying a standard for public accommodation by requesting a policy change. This is the way I understood his argument, and that the disability analysis only requires the interactive process for a specific exception. Do you have a comment on that argument that there was a legal problem in the analysis?
So I'm not sure why the investigator cited cases regarding public accommodations, because it is clear in the complaint that this was an a discrimination case. That said, I don't think it matters, because I think the standard is the same when it comes to accommodations. So whether you're a public accommodation or an employer or an educational institution, you are required to do the same thing: engage in an interactive process, provide the person who's asking for the ability to access your institution or your place or wherever you are with reasonable accommodations, so that they can enjoy the benefit of the school, the employment, or the public accommodation. So I think it's the same standard. The fact that there are some cases that relate to public accommodations rather than educational institution, I'm not sure why that is, but I don't think it matters, because here it's clear that as a factual matter, there was the appropriate desire to engage in an interactive process and provide the complainant with what he needed.
Thank you. I would ask counsel, do you have any comment on that? Whether there's an issue here or not?
There is not an issue here. Places of public education, community colleges are both places of education and public accommodations. And Attorney Huey has correctly told you that the standard is the same. The analysis is a reasonable accommodation analysis. There aren't a lot of education cases in Maine dealing with this, and we often use them.
And the report cites that the request is change in a policy or practice or procedure, which I think would cover the.
That is what a reasonable accommodation is.
Yeah. Thank you.
Any further questions for Attorney Huey? Seeing none, we will hear from Jane O'Reilly, investigator assigned to this case.
Morning, commissioners. It said, my name is Jane O'Reilly. I'm the investigator assigned to this case. Just to sort of start from there, the legal analysis to apply it to these specific facts, right? Complainant's counsel is saying that there is no policy in place. The practice of a class is the policy, right? The policy is these are the steps you take to pass the class. And he's saying, I need a modification of that policy to pass this class. I need, so that's in effect, you don't have to have a written kind of, this is the, the way we think of employment policies, or like it is the policy of this restaurant, to whatever. Often in education cases, it's just the standard set by the teacher as to what are the, grounds at which you need, or the things you need to meet in order to pass this class. So I don't really have anything else specific that I wanted to address based on what the attorneys presented. I think they outlined pretty clearly that my analysis in this case has to do with, he presented some information indicating he had a disability. They reached out and said, we need some more information. That communication broke down. Based on the record, they were the ones who were continually trying to reach out. And the law is designed so that it is on the complainant, on the person with a disability, to make clear what it is they need. We specifically do not want respondents assuming or making choices for an individual with a disability, what they may need. And so it was not on them to guess based on what they had, what specifically he needed. And also the fact that another university was, using that information to grant him an accommodation on a specific test doesn't really have bearing on a different situation with a different class, different institution. So, yes, it's true that they granted that accommodation, but it's also true that in this case, when they wanted to have a conversation with him, I'm happy to answer any questions.
Jane, thank you for that analysis about the policy, and it seems to be correct that the policy is how long you get to take the test, and the conditions of the monitoring and that kind of thing. But I wanted to ask you, it's not the case, is it, that the fact that the initial documentation was 30 years old was determinative and that they denied on that basis?
Correct. If
Responded still saying, yeah, we understand you're disabled, and maybe they wanted more current information, but they didn't deny on that basis.
right, if he had submitted, for example, a specific accommodation request with that documentation
Which was not
attached.
in that documentation.
Exactly. You just submitted the documentation. So if there had been a specific request associated with it, then it would be, does that documentation provide sufficient nexus between what he needs and what his disability is? The fact that they have a sort of stand, if they had said, we're not going to accept it, purely because it's not, within 3 years, that may have been discriminatory because that, there may be documentation older than 3 years that provides sufficient information. All the complainant has to do is make a specific request that is tied to a
Which is
disability
not in
related
that
need.
documentation.
Any other commissioner questions for the investigator? Amen. Thank you, Jane.
Thank you.
We've heard from the parties and the investigator. At this time, we are looking for a motion. There's one final.
I will move that the commission find that there are no reasonable grounds to believe that respondent discriminated unlawfully against the complainant on the basis of disability, and the complaint should be dismissed.
Second. Moved and seconded. Any discussion?
Well, that's the factual finding that he did not respond, and I don't see that that's contradicted or an issue that we should go behind, and therefore it's open and shut on that date.
The motion is to find no reasonable grounds. If you are in agreement, you will vote yes. Commissioner David?
Yes.
Commissioner O'Brien?
Yes.
Commissioner Walker?
Yes.
Commissioner Douglas?
Yes.
Commissioner Sanders?
Yes.
So the findings are no reasonable grounds. The commission will send a letter to the parties and the council confirming the results of the hearing.
Next case for hearing is E24 0114 Count A and B, Creanne Jones versus Mass General Brigham and Wentworth Douglas Hospitals. It is a recommendation for no reasonable grounds, both on the sex discrimination and I think it was retaliation. But in either case, we will hear from complainant first.
It's Jones, I believe it's here on Zoom.
Hello, yes. Are you able to hear me?
Yes.
Yes, I am here. Was having some IT issues earlier this morning, but I am present. And
You have 10 minutes, Ms. Jones. Do you want to save any of that time to respond after Attorney Abrams makes his presentation?
Yes, so I am agreeing. I'm not very formal and good with court stuff, but I am definitely wanting to move forward with my concerns of discrimination.
Right. What I'm asking you is we give the parties 10 minutes to present to the commissioners. You can save 2 or 3 or 5 minutes of that time if you would like. Use the rest of the time now and then use the saved time to respond after Attorney Abrams makes his presentation. So you'll present and then Attorney Abrams will present. And if you would like to save some time, you can then respond to what Attorney Abrams has said.
Yes, I'd like to respond after their attorney speaks.
No, you present first, but if you would like to save some time so that you can respond to Attorney Abrams, you can do that.
Okay, yes.
What is your total 10 minutes? How much time would you like to save?
I will save the max that I can for the end.
You have 10 minutes total. Would you like me to start you at 10 minutes and I can just save whatever time you have left?
We'll do 5 and 5 then. If that does that make sense? Splitting the time.
Fine. Whenever you're ready, go ahead.
Okay. So my name's Creanne Jones. I worked for Mass General Brigham Wentworth Douglas Hospital during the rebranding of their hospital going in from Wentworth to Mass General Brigham. Primarily, I worked out of the South Berwick Family Practice in Maine. It's their only Maine site location in the state of Maine. The rest are in New Hampshire or Massachusetts, typically found. And during my, about roughly 2 years of employment, I became pregnant well into after a year of gainful employment there, or I wouldn't really call it gainful employment. Being employed with no ladder or growth opportunities, I should say, being presented. And when asked, there was a lot of concerns before I announced my pregnancy. And I actually announced my pregnancy immediately the day I found out to my practice manager. There was a lot of animosity leading up before I even became pregnant regarding equal opportunity within the workplace and harassment and bullying that was going on that I had reported to my first practice manager. And then there was a second practice manager that was hired. So I had 2 practice managers in the under 2-year stint that I was with the company for. Which the first practice manager before I was pregnant, I focused strictly on what I needed to do and my professional goals and everything that I came to that practice to present and work on as far as getting my MHRC and getting credentials and keeping my MHRC because it was provisional at the time for 2 years and it was coming up to be expired and I wanted to renew that. But they disagreed to help with any professional developmental goals. Proceeded to write me up for basically anything that they never presented as their expectation or let me know from the gate during orientation with the company or anything as far as what company policies would even look like or how their practice operates, where they are the only state of Maine practice for the company and the rebranding. So I was very much oriented by and precepted by an older woman who had been with the company 20 some odd years and was very much stuck in the old ways of how the company Wentworth Douglas Hospital operated, not the merging of the new MGB policies and expectations that they were trying to implement and put into place. So I definitely feel like not only was my preceptor trying to sabotage me and my professional growth with the agency, but then once I became pregnant, it became a whole other level of boundaries and inappropriateness that was extremely concerning, and other new hires and new nurses that were onboarding with the company were even speaking about it and concerned, especially newlyweds that were looking forward to having a big family with their new husbands. It was blatantly obvious what was going on, and I just wanted, there's way more to say to that, but you guys know I've written a lot about back and forth about what really was going on behind the scenes there. And so it was definitely something that for any pregnant woman, thank God that wasn't my first pregnancy. But I feel as a woman and a mother of 2 children that I would never want anybody to have to go through what I went through, especially working in a medical field and for a hospital and giving birth at that hospital. And so it's something I strongly feel like it's important to stick up for other women if this was their first experience and they had a similar experience. And I want to note that this position was one of the lowest paying positions I've ever been paid for in my profession and field. So for them to act that foul for $18 an hour is what I was getting paid, like that to me blows my mind on a whole other level of equal opportunity rights and just how you treat a human being that has medical needs and real, how you would show
That is 5 minutes. If you would like to keep going, you can. If you'd like to save those 5 minutes, you can do that.
Mm-hmm. Yeah, we'll save the other 5 for the end after their attorney speaks.
Okay. Commissioner, questions for Ms. Jones? Commissioner O'Brien.
Thank you. I'm just bothered or confused by something that you've written in your response about, they wrote in your medical records about that you should be sterilized. Is that a true statement? I mean, can you
Yes.
talk about that?
So when I worked there, they said that I could access my own medical record charts, and thank God they did, because during this time I was getting prenatal care through York Hospital, and then their birthing center closed down halfway through my pregnancy. So I was forced to either give birth at Wentworth Douglas or Portsmouth Regional Hospital. And so while I was employed there, my preceptor said, you can access your own medical records as an employee here. So I made sure to do that when I transitioned right before I did 2 or 3 of my last prenatal cares right at the very end, right before I delivered my son with the hospital, because I was transferring my OB care from York Hospital because their birthing center closed halfway through my pregnancy and I was supposed to deliver up there. So I was observing my medical record very closely myself because of my transition and what I was personally going through in my health care at the time. And yes, the Dover Women's, Women's Dover Health there, the OBGYN office that I was connected with out of Dover, there was a provider that had written in my notes, and I had to call their office and say, like, that was not what we verbally talked about. I talked about sterilization for my fiance, Josh, as a possibility, as something he has discussed as a form of birth control, but I never, ever thought about doing that for myself. So when they asked, like, what birth control options you might use after having the baby, I said oral contraceptive is what I've always used. And that was then the
question. Ms. Jones, thank you.
Thanks.
Any other commissioner questions from Ms. Jones? Yes, Commissioner Douglas.
Ms. Jones, good morning. And congrats on the birth of your son. Yeah, so I'm looking at the report here and I just wanted to run through a couple of things with you. If you have the report, I'm specifically looking at the top of page 3. And it talks about sort of a final warning that you received for excessive cell phone use, using inappropriate language, not completing job tasks, and having an inappropriate conversation at the front desk with a member of respondent security team. So these are allegations. I'm not here to say whether they're true or not true. And then there, in the next paragraph, it describes how you were inappropriately giving medical advice. And so what I want to ask you about is on page 4, where it's about 2/3 of the way down the page, where the report says that you didn't dispute these things, but that you felt that your pregnancy precluded you from being discharged regardless of these performance issues. And I just want to make sure I understand. Is that actually your position?
So no, I never felt like me being pregnant meant I couldn't get terminated from a position, and if I'm not doing their performance expectations. But I definitely feel like they are manipulating the situation to their advantage and trying to take advantage and dock certain things, take advantage of someone who was clearly very not feeling well and being pregnant and dealing with a lot of emotional turmoil from their harassment over the year leading up before I was even pregnant, and then them playing fake nice. Oh, let's cover this up because this is a major lawsuit. And it's like the writing was on the wall before I even announced my pregnancy, and they said that my job would be secured, and they put on this facade like, oh, this is going to be your who's covering you while you're out on leave and when you come back, and then they terminate me the day before I deliver at the hospital, knowing I was walking around 5 centimeters dilated.
Thank you,
Yeah,
Majority.
I just wanna cut in here
Yeah.
because you've answered my question now. I guess what I was wondering about, it says in the report, you don't dispute any of these things that I just listed, like inappropriate cell phone use and inappropriate conversations and so on and so forth. And I just wanted to make sure that was the case.
I would only use my cell phone on my lunch break or if I got an emergency call from my OB or medical team. And as far as inappropriate language up front, I was sitting right next to the woman who was harassing me the whole time, calling me fat, starting all this drama in the practice. And so there was times I would mumble stuff under my breath out of frustration. Yeah, but I wasn't saying it loud for like anybody at the window to come through. It was more or less like basically telling this woman to go F herself kindly in a cordial manner because I am a respectful individual. But as far as when patients came in, no, I was very respectful to anybody that would come in, and I did what I could and breathed through my contraction pains and my back labor pain and everything else. And no accommodations were ever provided to me, by the way, or even asked. So going back to the case I just listened to with the education rights and everything, they didn't even ask, they didn't give me a sit to stand, they didn't even ask about accommodations.
Okay, I think you've answered my question.
No, never had one of those.
I think you answered my question. Thank you so much.
Yeah.
David?
Ms. Jones, following up on Commissioner Douglas' questions about those allegations, there's a very specific one, and I want it about you accessing the medical record of a person that you had a personal conflict with and had no authority to access that medical record. My question is a simple, did you do that?
So this was a patient that was coming into the practice for her PCP appointment, and I made sure to connect with the practice manager and say, hey, this may, I don't have a personal issue with her. It was more or less I worked with this individual before and I didn't like her on a professional level in the field.
My question then was, did you access her medical record?
Yes, because she came in and checked in for her appointment, but then I had the other PSR step in and take over that appointment because I presented the issue once I knew she was an established patient at that practice, because I had no idea that she was an established patient at that practice until after the fact. So once I knew she went there,
Jones, you've answered the question.
Made sure other PSRs would jump in.
Ms. Jones, you've answered Commissioner David's question. Thank you. Any other commissioner questions for the complainant? Seeing none, you'll have 5 minutes left when we come back to you. Attorney Abrams, you have 10 minutes. Do you want to reserve any of that time?
Sure. I think my initial response won't take more than a couple minutes, so I'll reserve 8 minutes, but I don't think there's going to be too much of a need for that. But yes.
Okay. Whenever you're ready, go ahead.
Thank you. I thank you so much for the time to address the commission. I'm here representing both Mass General Brigham and Wentworth Douglas Hospital, although Wentworth Douglas Hospital was the employer here. But I do represent both. I think we've indicated our response pretty clearly in our position statement. The issues that my client was responding to in terms of the issues that led to the termination were clearly based on performance concerns that were both legitimate at the time that they were occurring and clearly have been acknowledged throughout this process to have occurred. Even this morning, there was clear indication that from the complainant that the issues that we had with her predated any pregnancy announcement. My client was very clear about the concerns that they had related to the HIPAA issue, as well as the conversations on clinical matters with patients that were inappropriate, as well as the excessive cell phone use. There were all of those issues, and they were well described both before this case was raised in documentation and then described again in the position statement with appropriate evidence provided regarding these issues. And again, complainant, as you've noted already, really did not dispute any of the concerns that were raised by my client throughout this process. So we think that the rationale for the termination was certainly based in appropriate business concerns, not related remotely to her gender, to her pregnancy, or any other protected class issue. And we appreciate the Commission's initial review of this, and as well as your continued attention to the matter. Thank you.
Commissioner, questions for Attorney Abrams? You'll have about 7.5 minutes left when we come back to you. Ms. Jones, you have 5 minutes.
So as far as the main concern around my performance concerns being the grounds for termination, I want to make it very clear that that was something that they were using as an excuse to cover their own end. Because anytime I was willing to go above and beyond and to do things, and they were so quick. I mean, to want to make sure I couldn't climb the ladder corporately, don't get a merit raise, anything they could to sabotage and hurt my credibility and or reputation and moving up in that company was their mission. And my performance when I was there, I was very respectful to all patients that came through the window in the front door. And I did my job. I would check them out. I would ask questions. I was respectful to everybody, even if they were disrespectful towards me. I asked questions. I met with my preceptor. I would meet with my manager one-on-one. I brought all my issues to my manager, and there was no conflict resolution. We get a new practice manager in place, and she doesn't know what to do and handle a real crisis situation, let alone a healthcare issue for an employee. She's more looking out to, okay, cover this up and keep it moving, business as usual. Let's recruit new staff. And lied to this pregnant woman who experienced a very traumatic experience. Thank God it was my second live birth, because if that was someone's first experience, they would have died, okay? It's a real concern that this is, it's just, we write it as performance concerns and try to get her terminated for this. Anything we don't like, we're gonna scrutinize. No, this is a bigger issue that should be handled properly. And I will appeal this to the EEOC, because this is not okay. I don't care. I have clinical and medical experience. I don't care if that's what they're trying to go for, that is my performance concerns, because I was more than open and willing and very calm and kosher to learn and adapt and be calm, even when people were nasty as can be to me. And I felt like I was walking death because of how bad my pregnancy made me feel all the time. I showed up every day, even if I was 5-10 minutes late, like they wrote me up for. They don't know what my morning looked like. I could have been vomiting for 4 hours that morning to get there that day, but I still showed up for $18 an hour. Not okay. And what accommodation is that? You're supposed to accommodate a pregnant woman if she's having morning sickness. So, and no accommodation, nothing. So I'm just going to end it on that, because there is no question to me in my mind what happened there. I know what happened there, and they do too. And they should be ashamed.
Commissioner, questions for Ms. Jones? Being none, we'll go back to Attorney Abrams. You have 7 minutes and 27 seconds.
Thank you. I actually don't have any other comments. I think I'll stand on my initial comments.
Commissioner, questions for Attorney Abrams? All right, seeing none, we've heard from the parties, and next we'll hear from Carrie McCarter, the investigator assigned to this case.
Good morning, commissioners. My name is Carrie McCarter. I am the investigator assigned to this case. I don't have anything in particular to add, but I am happy to answer questions if you have them.
Commissioner, questions for the investigator? Seeing none, thank you, Carrie. We've heard from the parties and the investigator. At this time, we are looking for a motion. There is one proposed finding.
Yeah, I'll move that we adopt the proposed finding and find that there are no reasonable grounds to believe that Mass General Brigham Incorporated and Wentworth Douglas Hospital discriminated against the complainant on the basis of sex. The complaint should be dismissed in accordance with 5 MRS 4612 subsection 2.
Second.
Moved and seconded. Any discussion?
It sounds like there were definitely some issues in the workplace, but these issues predated her pregnancy, and I haven't heard anything to tie anything that allegedly went on at work to pregnancy or sex discrimination, anything like that. So I don't think we have a case here.
Go ahead. Ms. Jones, thank you for participating in this process. My hope is that you heard Commissioner Douglas's remarks. The reason that your case is likely going to be determined to have no reasonable grounds to believe that discrimination took place here is that though I hear it in your voice that you very much believe that there were violations of law and inappropriate things happening in your workplace, you haven't been able to demonstrate with evidence that your former employer discriminated against you on account of your pregnancy. So I just wanted to make sure that that was clear. And certainly we wish you the best of luck in your future employment.
What they said.
Okay. Any further discussion? Being none, the motion is to find no reasonable grounds. If you are in agreement, you will vote yes. Commissioner David?
Yes.
Commissioner O'Brien?
Yes.
Commissioner Walker?
Yes.
Commissioner Douglas?
Yes.
Commissioner Sanders?
Yes.
Okay. So the finding is no reasonable grounds, and the commission will send a letter to the parties confirming the results of the hearing.
Thank you.
And will that letter have the appeal process on it outlined?
I'm sorry?
Will that letter of no reasonable grounds have the appeal process in writing? Because the EEOC has a very strict timeline for me to appeal this decision.
I believe that the closure letter will have that information on it. And yeah, I think you have 15 days from the date of the letter to request an EEOC review.
Okay.
Thank you.
Third case for hearing is E24-0115 Flora Murray versus Walmart. The recommendation is that the commissioner finds that there is no reasonable grounds to believe there was discrimination on the basis of age or sex, and therefore we will hear from the complainant first.
Ms. Murray, are you here?
Public hearing.
You're on Zoom. And check. Jillian, will you check and see if you have anything from her?
I don't know anything. I don't see anything.
Appropriate for a motion?
So the complainant is not here. Since this is no reasonable grounds, that would mean we generally revert to the investigator's findings. If you have any questions, the investigator is available, otherwise.
Any questions for the investigator? Anybody inclined to challenge it?
I'm happy.
I'll move that we find that there's no reasonable grounds to believe that there was unlawful discrimination on the basis of age or sex. And the complaint shall be dismissed. Second.
Discussion? Hearing none, the motion is to find no reasonable grounds on both findings. If you're in agreement, you'll vote yes. Commissioner David?
Yes.
Commissioner O'Brien? Yes. Commissioner Douglas?
Yes.
Commissioner Walker?
Yes.
Commissioner Sanders?
Yes.
I don't think we need to break quite yet. Let's do the fourth case. The next case is E24-0129 A and B, Stephen Alexander versus Cross Country Healthcare and COVID Nursing Home. The recommendation is a split recommendation for no reasonable grounds on race or sex discrimination, but for finding of reasonable grounds on retaliation. The reasonable grounds being more substantial action by the commission if it was found. I think that would mean that we would hear from respondents first. Is that the way we do that?
So one note, please. I'll be recusing myself from this matter, the Alexander matter, and then the next matter on the agenda as well, which is Roush versus Seaport Community Health Center.
Right out. You have 10 minutes. Do you want to reserve any of your time?
Yeah, I think I'll probably use around 8.5 minutes. So I'll just plan to reserve whatever I have left, if that's okay.
Whenever you're ready.
Good morning. My name is Laura Rideout. I'm here on behalf of Respondent Cove's Edge. Thank you very much for the opportunity to present today. Cove's Edge respectfully disagrees with the reasonable grounds recommendation on complainant's retaliation claim. The recommendation hinges on the investigator's fact findings on pretext. Cove's Edge respectfully submits that its stated reason for ending complainant's temporary assignment were not fully reflected in the report, and that material evidence was omitted from the pretext analysis. This morning, I will briefly cover some relevant background information and then address the evidence supporting termination of the complainant's assignment and the key considerations for evaluating pretext. First, a little bit of background about the parties. Cove's Edge is a nursing home in Damariscotta. It offers skilled rehab, long-term care, and hospice services to its residents. Like many healthcare facilities, Cove's Edge periodically experiences difficulty filling vacant positions. And so when that happens, it works with a staffing agency to bring temporary workers on site to supplement its workforce while it's recruiting to fill vacant positions. Complainant was one of these temporary workers and was placed at Cove's Edge through his agency. He was offered a 3-month assignment from February through May of 2023, which was later extended through July 10th of that year. The month before complainant arrived at Cove's Edge, he had been put on assignment at another nursing home within the main health system. But that assignment was terminated after just 2.5 weeks due to some significant performance concerns, including sleeping during scheduled work time, arguing with patients, making degrading comments, neglecting to check on patients when asked, and then confronting other staff members after being questioned by facility leaders about these concerns. Staff at Cove's Edge reported similar observations while complainant was fulfilling his assignment. It's also the case that complainant engaged in protected activity by reporting discriminatory comments and patient care issues, all of which were investigated and addressed as appropriate. The first incident of his protected activity occurred on May 17th. Even though as early as April 3rd, Cove's Edge Director of Nursing had said in an email that she was not planning to extend complainant's assignment contract, the decision was made to offer him a renewal because HR was still in the process of investigating his complaints when his first assignment was coming to an end in May. On June 9th, not long after the renewal assignment began, Complainant submitted a written statement describing a conversation he participated in where another staff member described witnessing a coworker physically abusing a patient. This conversation took place 2 weeks prior to when complainant reported it. Per facility policy and state law, staff are required to immediately report any suspected patient abuse. Because there had been numerous issues over a 3-month period, the facility did not feel comfortable continuing with the assignment after this latest incident occurred. The 2 other staff members who participated in that conversation were also disciplined consistent with Cove's Edge progressive discipline policy. The investigator's reasonable grounds recommendation on complainant's retaliation claim is based on 2 findings. First, Cove's Edge terminated complainant's assignment because he failed to timely report the patient abuse allegation. And second, there was evidence of pretext because 2 other similarly situated employees were not discharged from employment for failing to report the alleged patient abuse like complainant was. Cove's Edge respectfully suggests that these findings do not fully align with the evidence in the record. First, complainant's failure to timely report the suspected patient abuse was not the only reason that Cove's Edge gave for opting to terminate the assignment. From April 3rd through June 7th, at least 6 staff members at Cove's Edge raised concerns regarding complainant's job performance and conduct, including that he left a patient's bed in an unsafe position, he was shirking patient care responsibilities, which led to a higher workload for other staff members. He was failing to check patient rooms. He was failing to follow the outbreak mask protocol. He was rude and disparaging, making rude and disparaging comments about other coworkers. He reported late to shifts, and he was confronting staff after they expressed concerns about him. Cove's Edge contacted complainant's agency on June 12th, requesting to end the contract, citing complainant's failure to perform duties as assigned and failure to timely report the abuse allegation on top of these previously reported concerns. The investigator acknowledged in the fact-finding section of the report that several performance-related complaints were made during complainant's assignment, but did not reference them when analyzing the retaliation claim. In support of the pretext finding, the investigator pointed to the fact that 2 other people were involved in the same conversation about alleged patient abuse, and while they received discipline for not reporting it, complainant was the only one who was discharged. In making this finding, the investigator did not take into account the following facts. The other 2 individuals were Cove's Edge employees, and unlike the complainant, they were subject to the facility's progressive discipline policy. Termination was not appropriate under the policy where neither of these individuals had prior corrective action or discipline. And unlike the other 2 individuals, complainant's failure to timely report was stacked on top of a growing list of complaints and performance concerns, and it was a culmination of these events that led to his assignment termination, not the failure to timely report in isolation. This was after Cove's Edge had shared feedback with the complainant's agency on April 3rd and May 17th, and the pattern had continued. Cove's Edge does not apply its progressive discipline to non-employed workers because they are on site for a limited amount of time, and it expects its agency partners to appropriately address performance concerns with its staff members. I also want to acknowledge that the record in this case was larger than most. There were 34 exhibits Cove's Edge submitted in response to the request for information and in support of its position statement. Many of these are written witness statements, emails describing concerns raised by staff, and witness interview notes. We appreciate that the investigator focused on a few of the key facts when synthesizing this large record to reach a recommendation. In this instance, however, Cove's Edge respectfully asks that the commissioners consider the bigger picture and the other relevance in the record, particularly as it relates to the decision to end the assignment and the pretext analysis. Thank you for your consideration, and I am happy to answer any questions.
Commissioner, questions for Attorney Rideout?
Yes, good morning. So I appreciate your presentation. You went right to sort of the heart of the matter. That's very helpful. So with respect to these two employees subject to the progressive discipline, if it's in the record, what does that progressive discipline look like, and where is that derived from? Is there a policy or?
Yeah. So basically, the progressive discipline contemplates numerous steps before somebody would reach termination. Of course, there's room to deviate from that for particularly egregious offenses. But typically, how the process would play out is there would be a verbal coaching in the first instance of a policy violation or a behavioral issue. And then there would be a documented verbal warning, and then a written warning, and then a final written warning, and then ultimately there would be separation. Included in the record is an exhibit that shows these steps of progressive discipline and the actual level of discipline that was issued to one of the individuals who participated in the conversation, showing that this was the first level of discipline in that process.
Great, thank you. And then in the report, it says that the complainant was terminated, his assignment was terminated for failing to timely report an allegation of patient abuse. Now, you've referenced a number of other things that factored into that termination. Is there a document in the record that sort of bears that out? Your contention that it's due to multiple factors?
There are a number of documents in the record that bear that out, which I've referenced in the objection we submitted. I mean, I could list off the exhibits if that's helpful, but like I mentioned, there's at least 6 witnesses who have written statements describing these concerns that were raised. There's 2 emails that went to complainant's agency describing some of these concerns. So it is well documented in the record that these concerns were taking place throughout the entire April 3rd to sort of June timeframe.
Right, but I'm asking about something a little bit different, and I do appreciate that. I'm asking about a document that says that this was the reason why his assignment was terminated.
Yeah, there is that document too. On June 12th, there was what's called an assignment issue form, which was sent to his agency, basically saying on top of these other previously reported concerns and not performing duties as assigned, and then this latest incidence of not following our policy of immediately reporting suspected abuse, we're at this time now going to request cancellation of the assignment.
Thank you.
Excuse me. You referred to the previous assignment, and that's from the same organization, the same provider in a different location?
Correct. Yep. Cove's Edge and the other nursing home facility, St. Joe's, are both within the main health system.
And does the record indicate that that record of that termination, which I think you said was after 2 weeks, that's a question. Is it clear in the record that that record of that termination was available to them before they terminated him?
Oh, the folks at Cove's Edge were not aware that that had happened. That's actually one of the issues in this case, is why was this individual even assigned by his agency to another main health facility after he had the month prior been terminated from another one? Our position is that that shouldn't have happened.
Thank you.
Any other commissioner questions for Attorney Rideout? Seeing none, you'll have about 2.5 minutes left when we come back to you.
Thank you.
Attorney Morris, you have 10 minutes. Do you want to save any of your time?
Good morning. Thank you. I don't expect I'll take all 10 minutes, so whatever's left.
Okay, whenever you're ready, go ahead.
Okay, thank you. Good morning, commissioners. My name is Sally Morris. I represent the complainant, Stephen Alexander, in this matter. Our position is that the investigator's recommendation finding that there were reasonable grounds to believe that retaliation had occurred should be adopted by the commission. I think a couple of the facts I want to focus on is the timeline. The report indicates, and there does not appear to be a dispute, that Mr. Alexander engaged in protected activity. He reported workplace discrimination based on race and sexual orientation, including very serious slurs, and reported unsafe patient care. The record indicates that he reported on May 19th to his agency, and then information was shared with the respondent. On June 9th, he made the report with regard to what the coworker had said. That conversation had occurred on May 25th, and then his contract was terminated on June 12th. So really right on the heels of making the report. As to the issue of progressive discipline and the other individuals being employees, as respondent has pointed out, and most progressive discipline policies will make an exception for egregious conduct. Our view is this should have been such conduct. First of all, my client is the only one who made the report. Second of all, the failure to report, according to the respondents, is a regulatory issue, a violation of statutory and regulatory obligations. Certainly such a conduct would be egregious enough to not follow a progressive disciplinary policy. Also, there are the issue with respect to my clients being the problem and these performance issues and whatnot. There is an extensive record here. There are a lot of witness statements. I would just say to the commission that the witness statements support what my client was saying about what was going on in that workplace. There were slurs. There was frequent egregious behavior on behalf of by the staff at Cove's Edge. And so I think the question of whether his performance, he was the one who had bad performance, or what was going on in that workplace was the issue. That's a factual dispute, at the reasonable grounds level. The question is whether he has an even chance of prevailing. And that heated of a factual dispute, we believe the investigator is correct in determining that there is a question of retaliation here. There is reasonable grounds to believe that retaliation occurred. As to the other 2-week assignment, as respondent has pointed out, if Cove's Edge didn't even know about the termination of that assignment, then it can't really play any role in the analysis of whether there was pretext here. So I think that our view is that this sort of last straw argument is defeated by the undisputed facts of what was going on in that workplace, that my client made a report. He was the only one to make such a report, and he was terminated on the heels of that. And I'm happy to answer any questions.
Questions for Attorney Morris? Being none, we'll go back to Attorney Rideout. You have 2.5 minutes if there's anything else you'd like to add.
Yeah, I'll just briefly respond to a few of the points that Attorney Morris raised. The first one had to do with why, for a regulatory violation of failing to report alleged abuse, that would not be the type of action that would warrant skipping steps of progressive discipline and growing straight to termination. The investigator's report kind of summarizes what happened with those underlying events. And this was basically a conversation where one coworker reported to two others something that coworker had observed. That coworker later described that she had embellished the events that she observed. She did not really believe that patient abuse had occurred. And Cove's Edge looked at that situation and admonished her for it and determined that where there wasn't other sort of progressive discipline that was active in her file, that is something that they could manage appropriately with corrective action short of termination. And the same goes for the other individual who heard that conversation, wasn't a direct witness. What's really different between those two individuals and complainant is that complainant had been at the facility for 3 months and 7 of his coworkers had come forward making complaints about his performance. And there were a lot of those. So comparing and contrasting someone who's a temporary worker coming on site to relieve staffing pressure for a short period of time with longtime employees who had clean performance records, that sort of explains the difference in treatment between those individuals. I also want to sort of clarify why I believe the termination from the prior placement at the other nursing home is relevant. it sort of supports the fact that the performance issues that were being observed at Cove's Edge are legitimate, and it wasn't Cove's Edge padding the file to support separating him, where the real pretext was because he had engaged in this protective activity. It shows that this same conduct was happening before he arrived at Cove's Edge, and it continued happening while he was at Cove's Edge. Thank you.
Commissioner questions? Yes, Commissioner Davis.
Excuse me. Are any of the other issues documented about this employee? In other words, he's not part of the progressive discipline because he's not an employee of the nursing home. Are the
Correct.
complaints against him other than the report about the patient care? Are they recorded in any written form?
Yes. There were 2 emails to the complainant's agency describing some of these concerns that had been raised. One of those emails was sent on April 3rd, and one of them was sent on May 17th. Both of those emails went out before complainant engaged in any protected activity. And then there are numerous emails and written witness statements describing the types of conduct that was being observed that was problematic, that was then shared with leaders who then would share that with complainant's agency.
And is any action taken on those reports that we know of?
Yeah, so that's part of the issue is Cove's Edge was saying in email communications in April that they didn't plan to renew his assignment contract, meaning, okay, we'll let him finish out the 3 months. We're not going to bring him back after that because he's too problematic in our workplace. Then he engaged in protected activity and made complaints about discriminatory comments. And Cove's Edge was in a hard spot because the time to renew the contract was when that investigation was still underway. Didn't want to prejudice him, recognizing that it could be perceived as retaliatory to deny an extension of his assignment while his complaint was pending, and opted to keep him on. And then additional performance issues continued to happen while his complaint was being investigated. And Cove's Edge eventually got to the point of saying, okay, we're not going to continue this any longer.
I'm sorry, what complaint was being investigated that led them to say they shouldn't terminate him while the complaint's being?
So the investigator's report didn't summarize sort of the discrimination complaint aspect of this case, but complainant Alexander sort of lodged complaints about racial and homophobic slurs that were being made in the workplace.
Right, okay.
Human Resources investigated that and took appropriate action to resolve it, including terminating the offending employee.
What is the date of the report and then the date of the termination? The date of the report of, yes.
The first time he reported those slurs was on May 17th.
No, I mean the report of the patient care, the serious incident.
That was June 9th, I believe. And the communicating to his agency that they were requesting that his assignment would be canceled was on June 12th.
Thank you.
Yes, so these findings of fact in the report, I understand it's just a sort of bullet point listing of facts, but do you claim that there's something material missing from that timeline there?
I do. Like I said, this is a big record, so I don't want to be unfairly critical of the investigator. I think the investigator, made a concise recitation of facts. I do think there are material facts that are omitted from that section of the report, and certainly from the analysis section.
Okay, and to be more specific, material facts relating to the complainant's sort of misdeeds at work.
Correct. Yep.
Okay, because the facts that we have here, I mean, there's the incident with the bed in the high position. Complainant fails to inform his coworkers when he left for his dinner break, and then, as you pointed out, his contract was renewed, right? And then there are the allegations of verbal abuse, which were found to be unsubstantiated. He's put out of work for a while and he's brought back, found to be unsubstantiated, at least according to the report. And then you know, there's this this whistleblower action that he does here, and then he's terminated. So tell me what's missing.
I don't know that I've prepared to sort of go through all of the sub paragraphs under section 2 of the findings of fact section and then filter in the ones that are missing. But
Right.
I've done that in my objection. So for instance, on June 6th, there was the allegation that complainant had referred to another staff member as a pedophile. That's not described in the complaint. On June 7th, there's an allegation that he had confronted the staff member who expressed concerns about his work habits, and sort of manufactured this allegation that he had been assigned more staff when the records showed that he was really only responsible for care of 2 staff members during that time period. So there are additional pieces of written evidence in the record that build out that timeline a little bit more during that time frame.
Right. And these 2 allegations you just referenced were June, right? Early June, and then he's terminated on June 12th, 13th, right? 12th, correct?
Right. Right.
All right. Okay.
Yep.
All right. Thank you.
Any other commissioner questions for Attorney Rideout? None. We'll go back to Attorney Morris. You have 6 minutes and 12 seconds left.
Thank you. I guess the only thing I'll add is that the record in this case, including all of those witness statements, made clear that these employees were accusing each other of various things. My client, what my client was accused of initially was unsubstantiated. And then what we do know is that he makes this report. Nobody else makes the report. His contract is terminated. The others are not terminated. So I think the depth of the record, it contains a tremendous amount of factual disputes, and that what is undisputed establishes that he was terminated 3 days after he made the report. And that's all. Thank you.
Additional questions for Attorney Morris? All right. Seeing none, we've heard from the parties, and next we will hear from Alex Ringland, investigator assigned to this case.
Morning, everyone. I'm Alex. I was the investigator assigned to this case. Let me just briefly give an overview of how I got to this finding. So, I think both parties really succinctly laid out their findings. However, what was really telling for me as the investigator to this case was the timing, which is laid out in the report. The really short timeline in between complainant's report of the alleged abuse and just 4 days later, 4 or 5 days later, the subsequent termination of his contract. Additionally, it was written in Attorney Rideout's submission of disagreements, belief that the other 2 employees were not disciplined because they didn't have prior discipline. That wasn't provided to me in my review of the record. The other 2 employees certainly were disciplined, but whether or not they had previous discipline was not provided to me, so I couldn't consider that in my possibility. Consider that during my analysis of this case, rather. I will say the facts were pretty tumultuous here, but what really stood out to me is that timing. He was the only one who made this report. He was, in fact, the only one who was discharged for the report. I'm open to any questions, really.
No questions for the investigator? Commissioner Brown.
Thank you. Could you, I think both attorneys commented on this, but can you talk about the fact that he was not an employee and progressive discipline?
According to the Maine Human Rights Act, he is considered an employee. It's not discussed in the record whether or not he was subject to the progressive discipline policy.
Any other commissioner questions for the investigator?
Can you shed any more light on the reason why complainant was terminated? So we've heard a number of different things. I'm not sure actually it really matters that much.
Yeah. I did pull up the document that Attorney Brideout referenced on June 12. That was the from Cope's Edge to his agency, stating he's complainant was not contacted this time. He's not a good fit. He has not performed his duties and failed to report allegation of abuse. I'm not sure if that was relayed to the complainant as to why his contract with Cope's Edge was eliminated. Regardless, I still think that my findings would remain the same.
Thank you, Alex. We've heard from the parties and the investigator, and we're looking for a motion. There are 3 proposed findings.
I mean, are we?
Only one of them.
Only one is
Only one
dispute,
of them,
right?
but you don't vote on them.
I would say that we take them all together, and we vote that 1, there are no reasonable grounds to believe that cross-country healthcare professionals retaliated against the complainant for engaging in MHRA and WPA protected activity. 2, there are no reasonable grounds to believe that Cove's Edge Nursing Home discriminated against complainant on the basis of race or sexual orientation. And 3, there are reasonable grounds to believe that Cove's Edge Nursing Home retaliated against complainant for engaging in MHRA and WPA protected activity.
That's right.
Moved and seconded. Any discussion?
So if you take this together
Right.
and you have one issue, you vote them all down. I think they should be taken separately, or at least the 2 that will.
I agree.
Well, I'm slow taker.
That's a lot of reading for you.
Yeah.
That's right. We can take them. So why don't we start with the easy ones, right?
We've got a motion that's been made and seconded, so.
Withdraw first.
Okay.
Yes.
Thank you. Good.
Just so that I feel better.
Now, council's happy. Do you agree, Mr. Walker, we can take these first 2?
Yes. Yes.
So I will move that we find there are no reasonable grounds to believe that cross-country healthcare professionals retaliated against complainant for engaging in MHRA and WPA protected activity, and there are no reasonable grounds to believe that Cove's Edge Nursing Home discriminated against complainant on the basis of race and or sexual orientation. These claims should be dismissed in accordance with 5 MRS 4612, subsection 2.
Second.
Okay. And seconded. Any discussion? Hearing none. The first motion is to find no reasonable grounds on the first 2 recommended findings. If you are in agreement, we'll vote yes. Commissioner David?
Yes.
Commissioner O'Brien?
Yes.
Commissioner Walker?
Yes.
Commissioner Douglas?
Yes.
Great.
I will now move to adopt the investigators finding that there are reasonable grounds to believe that Cove's Edge Nursing Home retaliated against complainant for engaging in MHRA and WPA protected activity. Conciliation to be attempted in accordance with 5 MRS 4612, subsection 3.
1 second.
Moved and seconded. Any discussion?
I would just say that I think both attorneys did a really nice job sort of outlining their positions here. I think based on this record, there is at least an even chance that the complainant prevails on this retaliation claim. So
I was quite torn about that this when I read it, and in fact I had thought that my conclusion was no, that there are not reasonable grounds. I clearly there are issues about his job performance. I'm impressed in the negative that his other assignment was terminated so quickly, but that was not before them in this action to finally terminate him. I think that the final conclusion is that was so on the fence back and forth that I have to go with the possibility that he might prevail at trial, if that's an even chance either way. And so I'm sort of reluctantly voting to find in the affirmative that there are reasonable grounds on retaliation. That timeline is just very, very quick, and pretty much triggered by that report.
Commissioner Walker.
I disagree. I am persuaded that it's not a pretext for him to be discharged, and that it is, not under the progressive discipline policy. So that would lead me to disagree with the reasonable grounds for it. And also, I waited to make my comment to see if you were going to say there are no reasonable grounds. So,
Okay, any further discussion? Hearing none. If you vote, the motion is to find reasonable grounds on the third finding. If you're in agreement, you will vote yes. Commissioner David?
Yes.
Commissioner O'Brien?
No.
Commissioner Walker?
No.
Commissioner Douglas?
Yes.
Okay, and because it's a tie vote, finding reverts to the investigator's report. So we'll find no reasonable grounds. Basically, we're adopting the report's recommended findings as written.
Really a close call.
Yes. So we will send the parties a letter confirming the results of the hearing and next steps as to conciliation.
We'll be in recess for 5 minutes. Is E24/0145 Nicole Roush. This is not about community healthcare. And the recommendations and finding of no reasonable grounds of visibility and retaliation. And therefore, we would hear from the complainant.
Attorney Morris, welcome back. You have 10 minutes if you want to save any of your time.
I expect I won't use all of the 10 minutes.
Whenever you're ready, go ahead.
Okay, thanks. Good morning again. My name is Sally Morris. I represent Dr. Nicole Roush in her claims against Penobscot Community Healthcare, Seaport Community Healthcare Center. Dr. Roush respectfully asks the commission to reject the recommended no reasonable grounds finding and instead find reasonable grounds to believe that discrimination has occurred on the basis of her disability and retaliation. Again, the commissioners are well familiar with the standard that what is at issue here is whether the record shows at least an even chance that my client can prove that unlawful discrimination has occurred. And we believe that there is at least an even chance. There are several important facts that support that position. First, Dr. Roush was the only full-time doctor at Seaport. She inherited complicated patients with long-standing opioid prescription regimens. The respondent was restructuring, caused increased patient loads and reduced administrative time, and the scribe service she had requested was interrupted. She took a medical leave in the spring of 2023. After returning, she requested a reduced schedule, and then within weeks, she received final discipline and was terminated. The respondent portrays the discharge of my client as relating to prescribing problems and documentation. First, I think it's important to note, and we did provide a letter in the course of the investigation to indicate that there's been no discipline against my client's license. The matter was resolved in her favor. But the record supports a different inference here. The performance concerns of my client arose out of the context of inherited clinical problems, reduced support, increased workload, and disability-related leave and scheduling requests that she made. My client began as a great employee. Her first evaluation does not describe any performance issues, and there was a review of prescribing practices in connection with that performance evaluation. No issues were noted. I also want to address the report indicates that the accommodation facts can't be considered because they're outside the time limit for a standalone failure to accommodate claim. But the law is clear that these facts can bear directly on motive, pretext, and whether the discharge followed the respondent's resistance to providing support. So they are relevant to this matter. And the timing here is important. My client was out on medical leave from April 24th to May 8th, 2023. After she returned, she requested a reduction from full-time to 80% time. On May 30th, 2023, she received a written warning in lieu of suspension, and on June 23rd, 2023, she was terminated. A reasonable grounds finding is warranted here because the record supports a plausible and evidence-based inference that the respondent used contested performance concerns that arose from management issues. The fact that she was the only full-time doctor, pre-existing prescribing issues with these patients, and reduced workplace support as a basis for terminating her after she made patient safety concerns and while she was seeking disability-related support. That's my presentation. I'm happy to answer questions.
It's not saying that she was reporting safety concerns with the paper. had to do with reorganization into the changes in the workload and assignment. How do you respond to that?
I had a little bit of trouble hearing you, but I'm understanding your question to be that, well, I guess I didn't, I guess I didn't hear your question. I'm sorry.
I think that the respondent. Never mind. I'll try to formulate it.
Questions for Attorney Morris? Maybe none. We have about 5 minutes and 52 seconds. Back to you. Attorney Rand in person. Good morning. Good morning. Say that's it too.
Katie Rand here for Knoxville Community Health Center. Dr. Roush's prescribing, so what she prescribed, how much, it's not disputed, and I will submit to you that reasonable people do not disagree about the propriety of it. But that question is actually not for you today. The question isn't whether the respondent did the right thing or the fair thing by terminating Dr. Roush's employment. The question isn't whether they were too conservative around prescribing or really second. The question is whether there's a decent good chance on the evidence that Dr. Roush can convince a fact finder that the termination is not because about treatments, but rather whistleblowing or disability discrimination. There are two unsurmountable barriers for Dr. Roush here. The first is the timeline, not the truncated timeline that Attorney Morris presented, but the bigger picture timeline. The second is the number of individuals where there's no evidence of knowledge of a disability or protected activity. Feedback sort of went into the performance management process. I want to sort of highlight some pieces of the timeline for you. First of all, the Controlled Substances Stewardship Committee, their input is very significant here. That is an interdisciplinary committee whose entire role is to assess appropriate and safe prescribing. In November of 2020, that committee reviewed the records from Dr. Roush's patients and sent some recommendations around tapering. They reiterated those in February of 2021. May of 2021, and I'll submit to you, this is before any electrical activities and long before any disclosure. May 2021, a colleague files a report with the licensee expressing concerns about prescribing to the same patient. The respondent supported Dr. Roush in responding to the board, and in that response, Dr. Roush represents that she will work with the patients to taper the patient's medication. January 2022, the board requests an update from the respondent around how that tapering is going. It's looked into. Not only has Dr. Roush not tapered the patient she represented, she's increased the patient's dosage, which she acknowledges was due to a math error on her part. June 2022, still prior to protected activity, prior to any need for a medical condition, she's placed on a written warning. She files a very detailed grievance. In that grievance, she essentially disagrees that there is something particularly problematic that justifies her treatment of this patient based on the bigger picture. Okay. Still pre-protected activity, pre-medical leave. Her grievance is reviewed by an independent or a third party who is not part of the decision to issue the warning. That warning is upheld. In October of 2022, we have the alleged protected activity, which is one of many doctors who, in response to an invitation to provide feedback, did so around some changes. And she affirmatively alleges that she was one of them. March 2023, the committee, the consultant committee, writes to the medical director that they have significant concerns about prescribing to a second patient.
April 2023, we have the FMLA request, which is the first notice that respondent has of a medical condition. She's out on leave in April 2023, May 8th, 2023. Upon return, she needs intermittent leave granted. She requests a reduction in her full-time status. Granted. In March 2023, just before going out on leave, the committee reports concerns around this patient too. She is placed on a written warning in lieu of disciplinary suspension, so advanced to the next step of the process. Concerns continue, and in June of 2023, she's terminated after learning from the committee that she's failed to implement recommendations that were given vis-a-vis 2 additional patients, 3 of them. So the timeline clearly reflects that whoever is right, whether respondent is overly conservative or not, there is just no evidentiary basis to suggest that they were embarking on this performance management process because they were upset with Dr. Rausch about protected activity or whistleblowing. And for that reason, I respectfully suggest you investigate about it, right? Any questions for Brand?
And then has a 2.5 minutes on it. Closed. Attorney Morris, you have 5 minutes and 51 seconds. There's any principle they have any presentation.
Thank you. I guess I'll be brief. I think, our response to this sort of progressive discipline timeline is that these are situations that were created by the circumstances of my client's work, which is what she was complaining about. The caseload that she inherited, the type of patients that she was inherited, the reduction in support, and then her termination follows immediately on the heels of her asking for a reduced schedule and taking leave. So our view is that we cited the relevant timeline, right? That it's the working conditions don't serve as the progressive discipline. They serve as the situation that created the problem based on the type of caseload that she inherited and the support that she had. Thank you.
Your questions for Attorney Morris? None. The Brand, you have 2.5 minutes. Is there?
I won't use 2.5 minutes, but I do just want to respond to the point that Attorney Morris just made. And I recognize that what you reviewed before this hearing does not include all of the underlying evidence. I will respectfully suggest to you that if you were to review the written warnings and the communications that were provided to Dr. Rausch over time, over several years time leading up to her termination, what you would see are effusive offers of support, both coming from the Controlled Substances Stewardship Committee and coming from the medical director. We will work with you. We know this is hard. We're going to do this together. And so I think nobody will deny that being a primary care clinician at this location is a challenging job, and that she had challenging patients on her panel. However, she had a wealth of support to support her in sort of taking action that was important to protect their safety, to be able to do so.
Your questions for Attorney Morris? Thank you very much. We have heard from parties, and next we'll have Bob Loshing, the investigator.
As you know, this is the investigator on the case. Really, both points, I think, answered the majority of the issues thoroughly. Again, as was noted in May of 2021, the decision covering all the complainant took it upon himself to report prescribing practices because of their concern. In this case, that was not initiated by the hospital, but rather by a court. Later on, again in January of 2022, complainants prescribing practices, it was determined at that point they were reviewing. She was already on notice of her concerns. At that point in time, approximately 6 months later, she was found to have only partially implemented the plan that had been put in place, and as noted earlier, in fact, increased the dosage, albeit due to a mistake at that time. So the hospital had good reason to be concerned that even though she was aware of these issues, she was not making sufficient progress towards tapering the medication as she had been directed. In April of that year, they restricted prescribing practices, and at that point informed her that now the tapering was mandatory. This was a month before her discharge. Again, it's important to note, and as it's been noted, that any alleged whistleblowing activity with respect to the reorganization happened months later. So clearly it was not a cause and effect as far as the earlier discipline, albeit the discharge itself came about afterwards. But again, there's nothing to suggest that the complaint she and others raised about reorganization were likely a factor in her eventual discharge. Again, in this particular case, the disability related leave that she took did predate her discharge the prior month. So there was a reason to look at that and see whether or not that might have been a factor in the discharge decision. But ultimately, again, in this case, once she was on the final written warning, they still weren't seeing the type of progress that they felt was necessary. And again, as complainant's attorney noted, this is a difficult job under trying circumstances. There's nothing to suggest here that the complainant was doing anything for her own regard or anything else like that. It was really just a question where she inherited a difficult caseload. I have no reason to believe that she wasn't looking out for her patient's best interest, but with the respondent in its position was ultimately responsible for her actions. And in this case, she saw the door coming long before they finally showed her to her son. She just wasn't in the office that they did. She did.
Bobby said it was 2 months before the discharge that she's restricted in her ability to prescribe because she's not making progress in the mandatory requirements to taper prescriptions.
Right.
So what happens in that 2 months that then triggers the discharge?
Again, just the lack of progress. Again, my understanding.
That lack in that 2 months.
Yes, there were no substantial changes. And at that point, she had been told direct orders as far as tapering. And again, it wasn't a question of it getting that much worse, but it certainly wasn't getting better at that.
And that's documented that in that 2 months she made the progress. After that fairly severe implementation of saying you can't prescribe it because you're not doing it.
Well, it wasn't fully restricted. My understanding is that when she had new patients, that there were some restrictions as far as they might be able to do. And again, if they wanted to discharge, it seemed as though they had more than ample justification at that point. They gave her this written warning in lieu of discipline to again give her that one final chance to show us some progress. And it just wasn't shown.
Other additional questions for the investigator? None, thank you, Bob. We've heard from the parties and the investigator. At this one, we're two proposed findings.
I'll move that we find that there are more to take them together and no reasonable grounds to believe that the complainant is discriminated, discriminated against on the basis of ability, more that she was retaliated against in relation to support protection of complaint should be dismissed.
Second. Moved and seconded, any discussion? Being none, the motion is to find no reasonable grounds on both counts. If you are in agreement, you'll vote yes. Commissioner David?
Yes.
Commissioner O'Brien? Yes. Commissioner Douglas?
Yes.
Commissioner Walker?
Yes. The next case is 824.
Oh, sorry. So the findings are no reasonable ground. The commission will send a letter to the parties and cannot the results.
D24-0147, Sean Sweeney versus UPS. And the recommendation is for finding of no reasonable grounds of multiple discrimination and their building of 13.
Sweeney. You have 10 minutes. Do you want to reserve any of your time?
I'd like to reserve anything I don't use.
Okay, we'll start you at 10 then. Whenever you're ready, go ahead. Minutes, yeah, actually, yeah,
You ready?
sure thing. Go ahead.
My name is Sean Sweeney, and I'm here today because I have cause to believe that UPS has discriminated against me, and many of my concerns were not properly addressed in the preliminary investigation. I don't believe that the investigator even addressed my 3.5-hour guarantee that I've been deprived. And UPS hasn't even told me why I don't get a 3.5-hour guarantee. According to my accommodation agreement, I'm entitled to the same contractual rights as every other employee. However, for years now, I have been deprived of many of these rights simply because I have a disability or an accommodation. For over 2 years, I've been deprived of a 3.5-hour guarantee, pay guarantee, which every other employee at UPS gets, except for me. I was granted that guarantee for the first year of my contract, but then for some reason, it was taken away. UPS still to this day hasn't told me why I don't get a 3.5-hour guarantee. I don't believe they told the commission why I don't get a 3.5-hour guarantee. And the investigator didn't even mention it in her letter to me about her decision. If taking a right away from me that every other employee in that company gets isn't discrimination, I really don't know what is. The reason that we're given that 3.5-hour guarantee is because that's what we need to meet our benefits so I can have health insurance and not have to pay in exorbitant amounts every month. In a letter from my Senate manager, which I submitted to you guys, he even says in that letter that I get a 3.5-hour guarantee. He's the very guy that then later on took it away from me. Similarly, in my accommodation, it is clearly stated that I shall be treated in all respects as a part-time local sorter, included for purposes of bidding rights, future part-time and full-time positions. However, when I attempted to sign bids on numerous occasions, I was denied, even though I was a top senior guy and should have got the job. Positions that require a bid are not rotatable positions and are awarded based on seniority. These positions would require me to sign the bid and have the most seniority in order to be placed in that position. Therefore, the respondent is unable to place me in that without my consent. Why would the ability to bid on a position be emphasized in my contract if I'm not allowed to change my own position? I've never heard of any company who has a more strict interpretation than would rather have the more restrictive interpretation rather than working with me, because my interpretation was much more flexible and would have allowed them to work me in more positions. Because my position is that they can't rotate me, but I can rotate me. And the main goal is to establish consistency and routine in order not to trigger my ADHD, not because I'm unable to perform all these other tasks. And I believe that the ADA requires UPS to maintain discussions with me if the contract isn't working for me or it's not benefiting me. I asked them multiple times to have discussions with me about the interpretation of my contract, and they refused to meet with me. They wouldn't even send HR up to talk to me. I don't know why their interpretation overrides my interpretation, and I don't understand why we couldn't have any dialogue about it. I also think it's important to note that it is required that a representative of the union is required to sign off on my accommodation. The investor even acknowledged that the union should have participated and signed off on the accommodation. The investigator mistakenly found that the complaint and the union accepted the agreement to the accommodation. The union is supposed to be an exclusive bargaining agent, yet the respondent did not involve the union in any part of the creation of my accommodation, nor did any representative of the union sign off on my finalized accommodation. Finally, I think it is crucial to acknowledge that for the first years of my accommodation, I was allowed to work on numerous shifts. When the contract was first signed, I was working in the small sort. However, during the holiday season, I was granted the right to work on the hub. In order to do so, I had to sign a bid for that position, and it was awarded to me. The hub is a completely different shift from the local sort, and they don't even have a small sort. I worked on the pick. The respondent is now claiming the only shift that I am eligible to work on is the local sort in the small on the local sort in the small sort. Similarly, for the entire first year, I would begin my shift early unloading packages, which is also an entirely different area and also not in the small sorts. This means that during the first year, I was allowed to work in 3 separate work areas. And then suddenly, I was not able to do that work outside the small sort anymore. I do not understand why the interpretation of my accommodation changed an entire year after its initiation, despite there never being a meeting about it and refusing multiple requests to have a meeting about it. I think it's quite obvious UPS is not operating in good faith and are weaponizing my accommodation to deny me income, health benefits, and full-time employment. I appreciate everyone's time today, and I don't think anyone should have to go through what I've gone through. I've been there 33 years, and I get the least amount of hours on my shift because they won't have pigeonholed me and weaponized my contract. So I appreciate you guys listening to me, and that's all I got. Thank you.
Commissioner David.
Mr. Sweeney, did you say that the union did not consult you about the agreement they entered into?
The contract specifically states that the union is supposed to be there when it's drawn up, and then they have to sign off on it. None of that happened.
They did sign off on it, did they not?
They did not sign off on it. They refused to sign it.
Questions for Mr. Susan? Seeing none, we'll have about 3.5 minutes left. Back to you.
All right, thank you.
Attorney Marshall, good morning.
Good morning. My name is Maya. Oh, sorry. Go ahead.
Yeah, that's okay. Do you want to say you have 10 minutes total? Do you want to reserve any of that time?
I'll reserve whatever's left over.
Okay, whenever you're ready, go ahead.
Good morning. My name is Maya Marshall, and I represent Respondent United Parcel Service Incorporated, UPS. UPS respectfully requests that the Commission accept the recommendation that there are no reasonable grounds to believe that UPS discriminated against Mr. Sweeney on the basis of disability, nor did UPS retaliate against Mr. Sweeney, and his complaint should be dismissed. So by way of brief background, Mr. Sweeney and UPS entered a new accommodation agreement in 2022 in which Mr. Sweeney would work in small sort and the local sort with management agreement not to rotate him to other positions. In accordance with this agreement, Mr. Sweeney works in the small sort role, and UPS has not rotated him to any other role or position. At the beginning of 2024, UPS lost business to a competitor, which resulted in a significant drop in the volume of packages processed at the UPS facility. As such, UPS was forced to reduce hours for certain employees, including those working in small sort. Despite this, Mr. Sweeney still received his guaranteed hours required under the CBA, which is the collective bargaining agreement. Mr. Sweeney has made requests to work in different roles and positions since. Specifically, he has attempted to place a bid for a UPS cover driver position that would regularly require him to work with a different department and drive in different routes every day. UPS has continuously, however, informed Mr. Sweeney that his current accommodation legally prohibits UPS from moving him to a different position. Although UPS has reminded Mr. Sweeney of the terms of his accommodation and encouraged him to request a change or modification to the current terms with the Human Resources Department, he has refused to do so. Notably, during the Summary of Issues and Resolutions Conference, he confirmed understanding of this, but then again continued to refuse to go through the accommodation process again. So to conclude, as Investigator Morse found, there is no inference of discrimination because Mr. Sweeney's accommodation prohibits UPS from moving him to a different position unless and until he submits a new accommodation request, which he's refusing to do, and Mr. Sweeney has not been retaliated against for his accommodation.
Attorney Marshall, I think you just said, and I don't hear you, was there any request to modify the agreement? That goes back to 2022. The agreement that we're talking about he says the union didn't sign, that's another question, but was there ever any request to change that written agreement?
There's been conversations, but Mr. Sweeney has not gone through UPS's formal process of requesting an accommodation. And we've discussed that with—
Accommodation that would be different.
Correct, yes.
What's your response to, I believe that he told me that the union didn't sign it. I asked him if the union consulted it.
Yes, I wasn't present for the formation of that agreement, but I will say UPS follows very strict policies and procedures when it deals with the union members and their accommodation process. And I also want to note that I believe Mr. Sweeney was represented by counsel at that time for entering into that accommodation agreement because this agreement came into place after he previously filed a lawsuit, and that lawsuit was dismissed kind of in exchange for an additional accommodation request. So he was represented by counsel during that period.
There's no question, but we have a signed agreement, right?
Yes, there is a signed agreement, and I believe it's exhibit in respondent's position statement. Let me pull it up.
Thank you.
The commissioners don't have the position statement, Attorney Marshall.
Okay.
Just report it.
Well, then, yes, sir, there is a signed agreement.
I just want to, before we start digging too much into this, I just want to caution you that the proper term that whether or not the union had to sign and whether or not there's a violation of the bargaining agreement is outside our purview. We're not allowed to interpret a collective bargaining agreement. So
right.
When we start focusing too much on what the union did and didn't do.
Yeah, no, I'm all right. Thank you. I'm going to do it. I just want to know if signed agreement.
Any other commissioner questions for Attorney Marshall? We don't have about 7 minutes and 40 seconds when we come back to you. Sweeney, you have 3 minutes and 30 seconds if there's anything you'd like to add.
Yeah, I have a couple of addresses. Number one, my attorney was not allowed per UPS policy to attend the meeting I had to sign my contract for my accommodation agreement. They have a policy that attorneys are not allowed to go, so he couldn't go.
Mr. Sweeney, get closer to your mic. Our volume is all the way up and we still can't hear.
All right, yeah, and so also I was rotated out of small sort on numerous occasions, so she made a false statement. And she said I never received a 3.5 hour guarantee. She's saying I received the guaranteed hours I was supposed to get, but that's another false statement. I was told by my center manager that I would no longer get a 3.5 hour guarantee, flat out, and I haven't gotten it in 2.5 years. I get 2 hours a day. That's it.
Questions for Mr. Sweeney? Yes, Commissioner Douglas.
Yes, Mr. Sweeney, good morning. What's the deal with the this alternate process, right? So you have an arrangement in place by your small store. ES says you want to do like a driving gig or something like that, then you need to file a request for new accommodation, and they allege that you refuse to do that. It's in the report. So I wanted to give you a chance to address that. Why would you refuse to do that? I guess, is that true even?
Well, the contract I have says I'm allowed to sign a full-time bid, so why would I accommodate something that gives me permission to sign a full-time bid? My contract says I can do it. Why would I need to change it?
Well, because you work for a big company and they say that's what needs to happen. Why wouldn't you do that?
Because I don't think that they've followed this contract in good faith. Why would they follow the next one in good faith?
Okay. All right. Thank you.
Any other commissioner questions, Mr. Sweeney? None. We'll return to Attorney Marshall. You have 7 minutes and 42 seconds.
Thank you. I only have one point to make about the guaranteed hours. This is an issue that, well, first, Mr. Sweeney's pay records reflect that he's been receiving his guaranteed time under the CBA. And then if this is an issue that needs to be dealt with through the grievance process. I don't think the commission and that this is not the proper avenue for Mr. Sweeney to deal with those complaints.
Can I say something about that?
No.
Okay.
Any commissioner questions for Attorney Marshall? Commissioner Douglas.
Yeah. So Mr. Sweeney says that he was rotated out of small sort from time to time, and sort of alleged that you made a false statement. Want to address that?
Yeah, so I'm actually not sure which year Mr. Sweeney is discussing. He's filed kind of several versions since 2022 for an accommodation. So if he's speaking about a prior accommodation, then he was rotated because the limitations around that accommodation were different.
Yeah. So is it your position that under this current accommodation, right, where he's in the small sort, that he was not rotated to another position because UPS would be legally prohibited from moving?
Correct. And that's what the basis of this complaint is, that he was not rotated.
Right. I just wanted you to address his statement that this had actually happened. Thank you.
Thank you.
Any other questions for Attorney Marshall? Being none, we have heard from the parties, and next we'll hear from Angela Morse, the investigator assigned.
Hello, I'm Angela Morse. I was the investigator assigned to this case. I don't have anything to add, but I'm certainly willing to answer any questions.
Any questions for the investigator? Being none, thank you, Angela. Heard from the parties and investigator. At this time, we're looking for a motion. There are 2 proposed findings.
That we accept the investigator's report as written. 1, there are no reasonable grounds to believe that UPS discriminated against shots against disability. 2, there are no reasonable grounds to believe that UPS retaliated against Sean Sweeney for engaging in WPA and or MHRA protected activity. And 3, complaint should be dismissed in accordance with 5 MRS section 4612 subsection 2.
Second.
Moved and seconded. Discussion? Being none, the motion is to find no reasonable grounds on both recommended findings. If you are in agreement, we'll vote yes. Mr. David?
Yes.
Mr. Brian? Mr. Walker?
Yes.
Mr. Douglas?
Yes.
Yes.
So the findings are no reasonable grounds. The commission will send a letter to the parties and council confirming the results of the hearing. Pause for just 1 minute. We're at 11 o'clock. We have 4 more cases to get through. Shall we order lunch? Or do you guys bring up hours and order it? Yes, before the. Pass around the menu. So you can write your order legibly with your name, size, any size, etc. Yeah.
No, sorry, we were muted. Try that again, Kit.
Okay. Mr. Van Alstine, can you hear me? Okay, can you unmute
Yes.
yourself? Okay, great. Sorry, we were accidentally muted for a moment. We're back online. Okay, so you have 10 minutes. Do you want to reserve any of your time?
Whatever the balance is, please.
Okay, whenever you're ready, go ahead.
Good morning. I'm Andrew Roberts Van Alstine, and I'm attending today to present my argument in conjunction with my letter to the Commission from April 5th that the child care facility failed to prove their defense. I'm sorry I'm not able to be there in person. It is my hope that the Commission will not accept the investigator's conclusion. Respondent has denied discrimination on their behalf, citing a safety concern, and claim that they did not discharge my child. These arguments are made with no unique documentation or other evidence that I did not also provide. And none of their documentation supports their claim that there was a safety concern. My son is autistic, nonverbal, and they knew this as in their child's 18-month evaluation of February 2023, which showed underdeveloped social and emotional growth. The facility, as I recall, was led by people with early childhood education that presumably includes recognizing neurotypical benchmarks or lack thereof. Given that knowledge, they would recognize and reasonably determine that my son had an intellectual disability that precluded him interacting with others as measured by neurotypical peers. My child is a member of a protected class. As the parent, I contracted services to afford my child the full benefit and enjoyment of a public accommodation. These services were denied, but provided to otherwise similarly situated children who received the full benefit and were treated better. The discharge from the child care facility was done for my child's disability and would not have been discharged but for that disability. Respondent claims of escalating safety concerns are unfounded. I and my family regularly notice that my child's food and water that was sent in was returned home untouched. With nonverbal autism, my child was unable to communicate his needs as a neurotypical child would. One burden the respondent should show is that the safety concern could not be eliminated by a modification of policies, practices, or procedures by the provision of auxiliary services or aids, citing 5 MRS section 4592. This flatly did not happen. There was no reasonable engagement with an interactive process to determine what modifications could be made. Respondent's only suggestion was to offer a potential return based on placement in the 2.5-year-old group, that group being led by a teacher whom my child had an existing relationship with. No other modifications or auxiliary aids or services were offered, suggested, or discussed. As a first-time parent with an autistic child, I don't know what I don't know, or don't know what to ask for. From my submitted audio exhibit of the August 8th conversation with the owner and facility director, the facility did not provide evidence of the incident they cited or discuss alternative solutions in that meeting that may have allowed my child to continue uninterrupted services. As part of the investigation, I submitted a clear timeline and daycare log, the entire ProCare message history between me and facility, additional follow-up emails, August 18th meeting notes, and 13 more exhibits across 175 pages. I can appreciate this was a lot of material to investigate. Based on the report, I felt the respondent's reply was taken at face value and my evidence not fully considered. Specifically, I believe the investigator's report erred in stating that my child could not move to the 2.5-year-old group due to state regulations. I feel more accurately, those regulations provide explicitly for a staff-to-child ratio, which does not outright bar my child's move to that room as a reasonable modification or aid, of which was not discussed. I believe the report erred in accepting the respondent's statement that my child's behavior escalated. Respondent provided no exhibits or evidence. Throughout my child's time at this daycare, there were at least 7 instances where I received a message or note from my staff that my child was the victim of other children's aggression, including being bitten repeatedly. I received incident reports on only 3 of those instances. To my best knowledge and belief, no other child was discharged from the facility for their behavior, and the facility failed to follow Section 3.7 of their own handbook. They did not create a behavioral plan per that handbook. There is a dispute about escalating behavior at the facility, contrary to the report. I believe, finally, the report erred in finding that we withdrew my child from the facility. On August 14th, the facility issued a letter submitted as an exhibit that, quote, "We have come to the decision that child's last day is to be August 18th, clearly discharging him from their service." I accepted the facility's story at that time on the good faith that it occurred until my repeated attempts to contact the owner after the August 18th discussion were ignored. The respondent's tactic in delaying and failing to communicate through September and October 2023 was pretextual to compel us to find alternative childcare and an abject failure on the facility's part to engage in the interactive process. Under 10-184, Chapter 32, Section 10, Right 8, children with disabilities have the right to reasonable modifications to childcare facility policies and practices. Respondent's claim of a safety concern is unsubstantiated with no evidence submitted during the investigation and is contrary to the evidence I provided showing my child was the victim of others' aggression, and this was a pretextual claim to discriminate based on my child's disability, citing their safety concern. Respondent was aware we began working with Maine Child Development Services. My child had their evaluation for that on July 26, 2023. Facilities claim that my child's behavior became unsafe only occurred and was escalated after we notified them of that, culminating in his discharge on August 18th. I feel that timeline is explicitly clear. My child was ultimately set up to fail and was constructively discharged by and from the facility due to diagnosed verbal autism. I thank you.
Commissioner, questions for Mr. Van Alstyne? Commissioner Sanders.
Thank you, Mr. Van Alstyne, and thank you for your advocacy here. We appreciate you accessing the commission and its processes to have a discussion about your concerns. So thank you for that. I just want to make sure that I understand something that I think I heard you say a moment ago, which was you noted, I believe, that in the course of these discussions about what was happening in the facility with your son, that the facility didn't offer any modification and that you didn't ask for because you didn't necessarily know what to ask for. in terms of modification. Did I get that right?
Correct. And I restated that in the audio recording submitted as an exhibit that I don't know what I don't know. I don't know what to ask for. You guys, as facility owners, childhood education, young experts, you're the experts. Help me understand what the options are. I don't run a daycare facility. You know, I generally, in every meeting I go into, I ask, tell me what I don't know, or, is there some service that I could be accessing? Is there some other resource? I don't know how to navigate the complex system.
Thank you very much. I also think I heard you say that you're concerned about other students who you believe were similarly situated to your son did not receive the same treatment. And so in other words, you believe that those students were allowed to continue to attend the program. And I guess my question is, how do you know that? How do you know that other students were treated, sounds like more favorably than your son was, while presenting the same kinds of behaviors?
Sure. So to clarify, I can affirmatively prove that my son was bitten repeatedly and the victim of other child's aggressions. Those were included in the ProCare messages, as well as other communications to and from the facility and us as parents. It is my reasonable belief that other children were not disciplined or corrected pursuant to that policy. As one, they can't tell me. I can't prove what I don't know. So unless they're willing to disclose what, if any, other action they took, what I do know is that I received only 3 incident reports concerning my child being the victim. I received no incident reports in which he had lashed out or acted with aggression to other children. I received no incident reports beyond those 3 of any of the other instances in which he was the one that was bitten, scratched, or otherwise injured.
Thank you. And so, as I understand it, then you don't have any information at this point that would suggest that those other children that we just talked about were engaged in a pattern of, this kind of behavior that was frequent and or escalating, like it's alleged that your son's was. Is that right?
Well, the respondent did not submit any evidence showing that they addressed similar situations with other students to be consistent with their own policy. And again, I can't prove information I don't have. That would be on the respondent to submit, then they didn't.
Commissioner O'Brien?
Thank you. First of all, as a first-time parent, I applaud your efforts. I understand fully you don't know what you don't know. I think your child is very fortunate to have someone advocating and pushing like you are. So on behalf of your child, thank you. I want to ask you, the Maine Human Rights Act, I'm quoting, does not require an entity to permit an individual to participate in or benefit from the goods, services, facilities, privileges, advantages, and accommodations of that entity when the individual poses a direct threat to the health or safety of others. And for these purposes, direct threat means a significant risk to the health or safety of others that cannot be eliminated by modification of policies, practices. We're talking about a child who's under 2 years old, and the term direct threat kind of seems little whatever. But are you, and also the fact that they are alleging that the center is alleging that they would need more staff and to supervise. Can you talk about that piece?
From what I know and participated in conversations with the facility, they did not offer more staff as a possible modification. They did not discuss potentially waiting until we had determined what CDS services could be available before issuing that discharge letter. There was nothing that they engaged with. Could they have moved him to a different classroom earlier? Could there have been a different child that could have gone elsewhere or aged up into the next classroom? There were no alternatives discussed with me.
Okay, thank you.
They had your child for a year, is that correct?
They had my child for a year, correct?
Okay. And their conclusions were based on that year of trying to care for him safely and with the safety of other kids, right?
I'm not sure I understand the question, sir.
Well, yeah, okay. No, never mind. Thank you.
Any other commissioner questions for Mr. Van Alstyne? Seeing none, you will have about 3 minutes when we come back. Are you Scott?
Good morning.
10 minutes. Do you want to reserve any of your time?
I'm going to be brief, so whatever time I have left over, I'll reserve.
Okay, whenever you're ready, go ahead.
Thank you. I represent Tree Frog Learning Center. Request that the commission uphold the investigative report in this. As I just said, I'm going to be brief, and I appreciate complainant's father being here, addressing his concerns, and I understand that. I'm a parent myself, but in this case, the filings, the investigative report, quite clear that simply after a period of time and numerous issues, both Tree Frog and the complainant's guardian were concerned, or his father, about their ability to safely care for the complainant at Tree Frog. There's just no dispute there were ongoing and escalating behavior issues with the complainant, with other children, and the teachers. And we heard about some of the information that was provided. And if you look at these back and forth, and there's constant messages about issues that occurred, yes, complainant was bit. But there were times, for example, where complainant walked up and hit another child, and then he was bit. So it wasn't just a one-off. And it can't really look, it wasn't just the complainant at fault here. These are young children, obviously they're interacting, they respond negatively, but the problem was this aggressiveness was causing issues. Tree Frog attempted to divert and arrest the behaviors. You see that in the messages, but they got to the point where they were unsuccessful. They were unable to do so. And eventually, as complainant's father in correspondence recognized these issues. They blamed it on various other reasons and factors. At the end of the day, Tree Frog did not believe it could provide a safe environment for the complainant and for others. The issue of the direct threat or a threat, it's not just related to whether or not the complainant might hurt others, whether he would be hurt as well. And that was the concern there. It was an ongoing issue, and it had escalated. Whether that reason was because there was a new teacher there, whether it was because there were other external factors, it's not really the issue here. The problem was it was something they could not address. Complainant's father agreed with the assessment. He blamed Tree Frog, but he refused to allow the complainant to return with the same teacher. He even stated, "I do not have confidence that his teachers are providing a healthy or safe environment for him." And the ultimate decision that Tree Frog could not provide a safe environment for complainant was not easily made, but is supported by the record. It was for legitimate, non-discriminatory reasons. When you look at we heard reference to the letter that was provided in terms of ending the relationship, but it ends with, "We would absolutely welcome him back after several appointments of whatever services CDS arranged for you." And there were communications. There was a meeting with complainant's guardian, complainant's father. There were communications back and forth to fill out the CDS forms. There was a discussion about moving the complainant to an older classroom, but Tree Frog reached out, was told he's not old enough to move into that other classroom with the older children, which would be a different staffing model. And because of that, was told, until that time period happens, we just can't safely have him here. And that was the result. It was for non-discriminatory reasons. There's no evidence here other children behavior escalated like this, or it was continuous and they were treated differently. It's just not what happened here. And so, as we sit here today, it's unfortunate. I think all the parties would have wished it would have worked out. But I think at the end of the day, these decisions that were made were for legitimate reasons, and they were for the safety of both the complainant, but also the other children at that facility. Thank you.
Commissioner, questions for Attorney Scott? Okay, seeing none, we'll go back to Mr. Van Alstine. You have 3 minutes and 8 seconds.
Yes, please. I would in reply cite that where Mr. Jackson said no other evidence, other children were treated differently. We can't prove that one way or the other. They did not submit anything as part of the investigator's report except their own word. I've also provided a very clear timeline where one, there were no communications in September or October about any plan to return to the facility. I was flatly ignored and then given the excuse that business was too busy for them at that point. In June and July is when we started to receive these allegations that the behavior was escalating. And those were coincidentally the same months where we had notified them that we had engaged child development services. Whether it's correlation or causation, I can't prove. Again, can't prove what I don't know. But we engaged CDS in June. That is when we started having these escalations occur. I don't feel like there was a good faith engagement to work with the facility, and I did not have any confidence in the teacher. Neither did my wife or my mother, who were all engaged in interacting with the facility, the teacher, and for my child's welfare. Where Scott says there were times when he hit another child and then was bit in return, there were no incident reports provided substantiating that. Again, the facility did not reply to this investigation with any material fact showing that my child was the cause of aggression towards other kids. The escalation in which I agreed was one made in good faith that knowing my child, he was more likely than not to try and hurt himself. He engaged in headbanging, which is a normal behavior for nonverbal autistic children. Being aware of that, we also told the facility that that was okay. He's expressing his emotions the only way he knows how. And we were more than happy to continue to work with the facility on achieving an understanding of what behavior was acceptable or not. Those discussions never occurred.
More questions for Mr. Van Alstine? Okay, seeing none, we'll return to Attorney Scott. You have 6 minutes and 1 second if there's anything else you'd like to add.
Sure. Thank you. So I just want to briefly point out here, keep hearing about there's no evidence that was provided to substantiate these concerns. And the reality is submitted were all these messages back and forth. Is there a picture happening? No, but at the same time, there's no challenge that, as we see these messages, the complainant hit a child and then was bit, or he's biting himself in December 6th. These are things that were documented at the time and they were contemporaneous. So whether or not, complainant's father believes or agrees with it, it's not really relevant here. You have contemporaneous documents here that show this back and forth. There wasn't a challenge that it was occurring at the time. Whether or not an incident report was filled out or provided to the complainant is a bit irrelevant here. And so this is a situation where first this was raised the whole time and it was continued. The thing about the CDS didn't come up until June 15th when there was an incident that occurred, and then the school was told we're looking at CDS, and it was said, hey, great, let us know. And actually there's emails after that, and we saw the letter where it said, let us know what kind of recommendations they provide. So the whole time there was interaction back and forth. And even after August, there was discussion about moving to another classroom. The idea that there was no communication is not accurate. There was discussion about moving to another classroom. There was, let's look at September 25th starting. And then admittedly, Tree Frog, who was opening another center, didn't respond right away. Complainant's father reached out and before the 25th and asked and was told, look, sorry about the delay, but we reached out to the state. We're told that we can't have him move to this older group. He's five months too young. And so we're not comfortable having him move back with that number of kids and that size. There was communication the whole time. I understand that this is a tough issue. It's certainly, I respect that, but the reality is there was an ongoing effort. They weren't able to address these concerns. And at the end of the day, this was not going to be a situation that was going to work for either party. And there were real concerns about what was going to happen going forward and whether it was a safe situation for him or for others. And the decision was made, they had to move on. And that's what occurred here. Thank you.
Questions for Attorney Scott? Being none, thank you both. And next we'll hear from Carrie McCarter, the investigator assigned to this case.
Good morning. Still good morning. My name is Carrie McCarter. I am the investigator assigned to this case. I think the parties have both laid out their positions similar to what they submitted to me. I don't have anything to add, but I am happy to answer questions if you have any.
Are questions for the investigator? Seeing none, thank you, Carrie. We've heard from the parties and the investigator. We'd be looking for a motion. There is one proposed finding.
I'll move that we find that there's no reasonable grounds to believe that Tree Frog discriminated against complainant on the basis of disability. And the complaint should be dismissed.
Moved and seconded. Any discussion? Go ahead.
Well, I mean, I think complainant would have to show some indication that the stated problems were pretextual, and clearly they were not. They were not able to provide a safe a safe environment both for that child and for the others that were there. I don't detect any animus of unlawful discrimination.
Yeah, I'm gonna vote for that, that motion. Because of something that the last, I believe, paragraph, of our investigative report, that his behavior may have been due to his disability, but it doesn't mean that removing him from the program was discrimination. He was not permitted back due to his behavior, not due as an individual with a disability. So there isn't really the nexus between discrimination and what happened in my mind, unfortunately.
Any further discussion? The motion is to find no reasonable grounds. If you are in agreement, you will vote yes. Commissioner David?
Yes.
Commissioner O'Brien?
Yes.
Commissioner Walker?
Yes.
Commissioner Sanders? Yes. So the findings are no reasonable grounds. The commission will be in touch with the parties as to the results of the hearing.
Next case is E240186, Daniel Brubaker versus Amazon. The recommendation is for findings of reasonable grounds on 2 counts, and therefore we will hear from respondent.
Good morning, Commission. My name is Ashley Wydrow. I am outside counsel for the respondent Amazon.com Services LLC.
Morning. Do you want to reserve any of your 10 minutes?
I'll reserve 2 minutes, please.
Okay, whenever you're ready, go ahead.
Thank you so much again to the Commission for the time to address you all this morning. Amazon respectfully disagrees with the investigator's findings of reasonable grounds of disability, discrimination, and retaliation. The matter comes down to whether Amazon's actions in placing complainant on a performance improvement plan, which ultimately led to his separation, can be tied to a discriminatory or retaliatory intent, and Amazon is adamant it cannot. Complainant failed to meet the expectations and requirements of his role for several months and was placed into focus and later moved into pivot for legitimate, non-discriminatory, and non-retaliatory reasons. Amazon's actions in managing his performance were set into motion before the disclosure of his disability or any protected activity. Amazon appropriately and consistently followed its own policies and procedures and treated complainant the same as any employee who showed performance deficiencies in their role, and did not treat complainant differently due to his alleged disability, other than to pause the pivot plan during his medical leave of absence, keep it paused pending his accommodation request, and pause it again during the investigation into his internal complaint. Those pauses were favorable to complainant because he was provided more time to turn his performance around, and he was ultimately provided 2 more months than his counterpart to submit a sufficient organization planning document. Overall, Focus is a performance management tool that's flexible. Typically, it would be for 30 days, but it could be extended. This process involves one-on-one coaching and feedback by a manager attempting to turn an employee's performance around with more targeted feedback and guidance. The employee's ongoing performance is tracked with detailed notes by their manager throughout Focus. And if an employee shows no improvement in Focus, the manager recommends moving the employee into Pivot with HR approval. Pivot is a formal performance improvement plan meant to give the employee specific expectations to meet within 30 days. A pivot plan is prepared by the manager based on the employee's current projects and expectations that can be completed within the next 30 days. In other words, they are not given additional expectations or less time to complete projects just because they are placed in pivot. The plan is then approved by HR and delivered to the employee in a meeting to review the pivot plan expectations. Pivot is paused if an employee requests a leave of absence, has an accommodation pending, or files an internal complaint to ensure those issues are resolved before holding the employee to the expectations of the pivot plan. The employee has the option to resign and accept a severance or stay and complete the pivot plan. If they choose to stay but fail to successfully complete the plan, the employee is again offered the option to resign and accept a severance or the opportunity to appeal the pivot outcome. The investigator's findings emphasized the timing of complainant's pivot plan and a misconception regarding the amount of time complainant was given to complete the pivot plan. So we submitted a detailed explanation in our filed objections to specifically clarify that timeline. Complainant's prior manager entered him into Focus for performance issues over the previous several months. Complainant's second manager took over the Focus management and coaching based on the previously documented concerns and feedback provided. Complainant's second manager entered him into Pivot on December 1st, which set the pivot plan into motion, even though the pivot plan itself had not yet been finalized and delivered to him. In December, complainant requested a medical leave of absence related to a medical condition, which was granted. Upon his return to work after his leave ended, he requested an accommodation to work from home related to a medical condition, which was also granted. Neither his leave nor his accommodation request provided any reason to change the expectations of his role or remove him from Pivot. Complainant's pivot plan was paused during his medical leave and while his accommodation request was pending, which followed Amazon policy. Once those were resolved, the second manager created a pivot plan based on complainant's current projects and expectations. HR approved the plan and it was delivered to him in March. This plan included the requirement to submit an organization planning document referred to as an OP1. As the second manager and the HR representative explained during the Issues and Resolutions Conference, the OP1 is a typical requirement of complainant's role, and even before the delivery of the pivot plan expectations to him in March, he was well aware the OP1 should be submitted around April. And he should have already been working on it by that time and had been well on his way to completing this expectation anyway. After the delivery of the pivot plan, complainant filed an internal complaint arguing that the pivot plan failed to take his accommodation into account and held him to different standards than his counterpart. HR investigated and could not substantiate the claims. Specifically, HR confirms that complainant's accommodation to work from home did not change his expectations in any way, and he was not being held to different standards than his counterpart. His counterpart actually had more responsibilities than complainant because he oversaw a larger business line than complainant. Complainant's pivot plan was again paused while his complaint was investigated, but he was still expected to complete his typical job duties during that time. However, he still did not submit the required OP1 as expected in April. Nevertheless, his counterpart did meet that expectation. When his pivot was redelivered in May because the OP1 document had still not been successfully completed by complainant, it was again included as a requirement in the updated pivot plan due mid-June. The management assessment form contains detailed feedback, making it clear the OP1 document he submitted by mid-June was not considered complete or sufficient and did not meet the bar for his role. Additionally, complainant did not provide work product that fulfilled the other expectations of the pivot plan. So just to summarize some of the factual questions over the expectations in the pivot. Pivot is always meant to be a 30-day plan. He was entered into pivot on December 1st, but the initial pivot was not actually delivered to him until March. Expectations that were ultimately approved and delivered in March were based on his role's expectations at that time. His current relevant project was the OP1 document, which would have been expected in April anyway. At the conference, Amazon's witnesses corrected the misunderstanding that the December 1 pivot plan gave him 4 months to complete an OP1 document. As they explained, the pivot plan was not actually written and delivered to him yet, but when it was written and delivered in March, he was given 30 days, which is a typical pivot plan deadline and turnaround time. So specifically, there seems to be a misunderstanding that somehow his deadlines were shortened or changed, but again, that has been cleared up. Complainant had still not completed his OP1 document in April as required. Once he was redelivered the updated pivot plan in May, he was ultimately given until June to complete that expectation, leaving him actually more time than his counterpart to complete the project. However, even upon his submission of his final OP1 document, it was still determined that he had not submitted a sufficient OP1 document that met the bar of his position. None of Amazon's actions can be traced to any discriminatory or retaliatory intent. To the contrary, complainant was granted a medical leave of absence, an accommodation to work from home, and HR investigated his complaint, all of which actually gave him more time to turn his performance around and submit a sufficient OP1 document.
Commissioner, questions for Attorney Wydrow? Yes, Attorney Sanders.
Great. Good morning, Attorney Wydrow. It may be just me, but I'd love to be able to slow it down a little bit and just ask you some basic factual questions that are not clear to me in the record. The first is, can you just describe for me very generally, what is the job of a business intelligence engineer manager?
Sure. I can certainly do my best. Just look through my notes. I don't see that we included like a job description in our response. My general understanding is that it's some sort of software engineer. And in his role as a manager, that he would have also been not only reporting to his own manager, but he also oversaw some direct reports who would have been completing projects to contribute to the team as a whole.
Okay, and I'll certainly direct that question to the complainant as well.
Okay.
Also curious too, on pages 3 and 4 of your objection to the investigator's report, you lay out the areas of improvement that your client alleges the complainant needed to demonstrate. Candidly, I read through those areas of improvement and they're so jargony and sort of using corporate language, but I can't make any sense of it. And so I'm wondering very succinctly, could you give us a description of what were the sort of what are in plain language the concerns that that your client raised about the complainant's performance?
Absolutely. Timing of deliverables. So simply put, missing deadlines, missing internal deadlines with stakeholders, resistance to incorporating feedback. So again, resistance to, when receiving direct feedback, resistance to incorporating that feedback to improve the projects and documentation, despite receiving that direct feedback. And an unwillingness to partner both with his direct manager and his direct reports on providing specific metrics and strategies on how to specifically improve and overcome obstacles that his team was facing. So for example, the team had an obstacle with meeting sim ticket deliverables. And
what is that?
A sim ticket is a specific request submitted internally when someone is having an IT or technical issue. So raising a sim ticket would be when someone within Amazon has an issue that needs to be addressed by the team. And as a manager, a business intelligence engineer manager, Mr. Brubaker would have been in charge of reviewing his team's metrics and overall performance and strategizing to specifically improve those processes.
Okay, thank you.
Sure.
Any other commissioner questions for Attorney Weigro? None. You'll have about 2 minutes when we come back to you. Attorney Fox. Do you want to save any of your time?
2 minutes, please.
Whenever you're ready.
Good morning, commissioners. My name is Maria Fox, and I represent Daniel Brubaker, who's here with me today. We're asking that the commission adopt the investigator's recommendation that there are reasonable grounds that disability discrimination and retaliation occurred in this case. Mr. Brubaker has a diagnosis of post-traumatic stress disorder based on a history of surviving armed robberies and a school shooting. He was hired as a work-from-home employee for Amazon. He worked here in Maine, and the office is based in Boston. So he was hired to work from home. After over a year, Amazon decided to institute a return to office policy, called everybody back to the office, even though Mr. Brubaker primarily Zoomed with people all over the country and didn't really meet with anybody in Boston. They were requiring him to go there. He was vocal with his objections to returning to the office, driven largely by the impact that he suspected it would have on his PTSD symptoms. His supervisor really wanted people to come back to the office and was very upset with Mr. Brubaker for being as vocal as he was. And that is noted as in the focus document that's been mentioned. It's the first thing, the primary behavior in this focus document is, quote, behavior impacting performance, close quote, characterized as Mr. Brubaker allegedly making a public rant about returning to the office. So there's already this tension, right, between them about this. He went back to the office. He was directed to do that. commuting to Boston, dealt with unannounced fire alarms, had an altercation or negative interaction with some construction workers. His PTSD symptoms were worsening. HR knew about this in September. His supervisor knew about this in October. Everybody knew about this in mid-December when he went out on family and medical leave to go to an inpatient psychiatric program. He was out on that leave until he returned to work in mid-February of 2024. And he returned with an accommodation request that was granted for him to work from home, because that's what he really needed. This did not please the supervisor. As I mentioned, this focus that he wasn't aware of at the time is that. Mr. Brubaker was unaware of any supposed performance issues. There were no performance issues. In fact, he had good performance reviews up until this return to office situation arose. The first that he learned that there are any supposed performance issues as a pivot. This pivot is issued to him in March of 2024. And he's given 5 weeks to prepare this OPI-1 report, which he had never before been required or expected to do. This was the first one he's doing. And he's given 5 weeks to do it. Not 30 days, as well, I'll get into in a moment, but he's given 5 weeks to do it, which is very short period of time for that type of report. So he escalated, did an internal discrimination complaint, and they did pause it for that period of time and claimed they were unable to substantiate the discrimination complaint. But we've seen no records and there's no documentation that we've been provided for this supposed investigation. They changed the deadlines, but they kept it at the 5 weeks. He did his best under that extreme time pressure. And I'll just note, his counterpart, on the other hand, had at least 5 months to do a similar report. He'd never done one before, was never asked of him to do. He went back, he did the best he could, delivered a 24-page report to satisfy the pivot as best he could, and went back into the hospital immediately for an inpatient program, and told his supervisor on his way, sort of delivering this report, that he's going into the inpatient program, that he had limited communication, that the only way to communicate with him would be through his wife or his attorney. His supervisor withheld this information from HR and made it seem like he had abandoned his job to get him fired. And Mr. Brubaker was released from the program or graduated from the program about 4 weeks later and returned to work just in the nick of time to kind of undo that situation. So he wasn't terminated then, but the supervisor said, "Oh, but you've failed the pivot. You haven't satisfied the pivot." Providing a single paragraph with jargon, no specific examples, except, and I'll just say, except that he supposedly he set meetings for stakeholders at inappropriate times, and that's sort of repeated. And then there's, he had already discussed with the manager the timing of the stakeholder meetings, and that it was appropriate for him to, seek written input from stakeholders. And he got very few responses that way, got very few responses all around, but did the best he could. This was a setup for failure, and none of this makes sense. The focus document, there is a document that surfaced after the fact, after he was fired. He requested his personnel file, didn't receive any focus document until this MHRC process. Now a focus document surfaces and suggests that, they had been secretly documenting performance issues dating back to sometime in the fall. It appears from timing that it may have been the supervisor who was angry with him about him being vocal, right, about the return to office work, because that's the main thing that she lists. It's the first thing and the main thing that she lists. We also learned that the initial pivot, the document for the initial pivot that they drafted before he went out on medical leave, provided for 5 months for him to do this OP1 report. and that they had held him to 5 weeks after he took the medical leave and everybody knew he had the PTSD. That seemed to make a whole lot more sense because of his counterpart, who had at least 5 months to do an OP1 report. And that counterpart has no known disability, didn't take a medical leave of absence, as did Mr. Brubaker. The respondent, Amazon, is saying the pivot, we adjusted it for the current projects and all of this. It's identical. The language is identical. I think maybe the font is different, but the dates and the font are different. But otherwise, it's the same thing. They say he could have been working on the OP1, but the pivot itself, if you look at the language that was given to him in March, it doesn't say continue to build an OP1 report. It doesn't say, you're building an OP1. It says build an OP1 report. They knew that's when he was starting. He'd never done one before. He had a full load anyway in terms of what he had on his plate. So
that's 8 minutes.
Okay, thank you. There are other irregularities about all of this. His supervisor shifted in the fall before he went on a medical leave, and if you were to believe what's documented in this supposed focus, according to Mr. Brubaker's experience as a manager for Amazon, Amazon doesn't shift supervisors if you have performance problems. And so a focus also has to be approved by a split level manager to sort of, make sure that this is being done properly. And here what we see is his manager in the fall sets him on this course for the focus, but has a new manager that he's now going to be reporting to be the one to sign off on the focus so that she can be the split level manager for him. So that's also irregular. I will stop there. I'm happy to answer any questions, but we think the investigator got it right here.
Questions for Attorney Fox?
Jargon. Could you explain what the OP1 report is?
Oh, I'm not sure that I would be able to exactly describe it.
It takes 5 months.
At least 5 months, right? I mean, it's an overview, and just to answer, I know that there is a fair amount of jargon in the submissions by Amazon, and we would submit that the supposed feedback he was getting wasn't specific at all. There weren't examples. I mean, his job was to oversee analytics and data infrastructure, and the OP1 report gathers a bunch of data. He's got various supervisors. They're trying to improve the data analytics, and they have tickets for problems that are prioritized, depending on what the issue is. I'm certainly not expert in this area, as you can tell, but it's a major project, and it wasn't something that was a necessary part of his job. It was something that he may be asked to do, I believe, is my understanding, but it wasn't something that was sort of essential to his job. It was very much tied to this pivot plan. And so when it was paused, he had a full load. He didn't know, whether they were still going to be requiring him to do this because it was on appeal or it was being paused for various reviews.
Attorney Fox, when was the accommodation granted?
The accommodation for the work from home?
Yeah.
That end of January
What year?
of 2024.
Of 2024. And so that's in place, that granting of that accommodation and desire to work from home.
Yes.
And your sort of overall theory of the case is that the supervisor's unhappy with that having been granted and other people having to return to work. Did the accommodation require some return to work? Did he have to go 1 day a week or nothing like that?
No, I mean, he had been effectively doing his job. There were no performance issues with him doing his job fully remote when he was hired into a fully remote position.
Well, that was during the pandemic.
Well, I guess it depends on when you define when the pandemic was, but it was 2022, 2023.
Well, I'm correct that your theory of the case is that she's, I think whoever the supervisor is still trying to amass stuff to get it because they're displeased with the accommodation having been granted, right?
That's exactly correct. So she's initially angry,
Right.
and he's vocal about it.
The final stated reason is failure to complete this report.
He failed the pivot, is what they said. He didn't successfully complete this performance improvement plan called a pivot. So they terminated his employment based on that.
And the investigator finds that they didn't show that was not retaliatory for what?
The retaliation is for his having requested accommodations for his disability and, you know, having been granted and taking advantage of the reasonable accommodations that were granted.
To work from home.
Correct.
Thank you.
And taking the medical leave.
Any other commissioner questions for the lead box? Being none, you'll have about a minute left.
Okay, thank you.
Attorney Wydro, you have 2 minutes and 9 seconds if there's anything else you'd like to add.
Okay, sure. Thank you. I just want to clarify a couple of things. First, complainant was not hired to work from home. Complainant was hired to a position that was tied to BOS 21, which is the Boston corporate office, in 2022. At the time, COVID temporary policies were still that everybody was working remotely. In mid-2023, Amazon rolled out its corporate return to office procedures that affected everybody widespread. Managers and even HR had no discretion to allow anyone to be excluded from those policies. The only exceptions that were being made were for people who were requesting medical accommodations, which is through a different department called Disability and Leave Services. That's a centralized team, and when complainant used that process, his accommodation was granted. Second, I would like to clarify that complainant was not changed managers due to performance issues whatsoever. There was simply a reorganizational structure within the team. His original direct supervisor was moved up to become his skip level manager, as Ms. Fox explained. But that was not specific to him or his performance issues. That was just a complete reorganizational shift in the team itself. I also wanted to clarify when the whole idea of this public rant, that was mentioned in his first manager's entry of him into focus, because he was becoming very disruptive during team meetings about disliking the return to office policy. But the discussion was not about an accommodation. It was due to his complaint about the commute time, and that negative behavior was impacting the team as a whole, which is why that comment was made in the focus. But the focus clearly has that listed as one of many comments as to why he was entered into focus, and Amazon disputes the characterization of that as being the primary reason he was entered into focus. Additionally, the second supervisor is the one who determined he had not turned his performance around and entered him into pivot. Okay. Thank you.
Commissioner, questions for Attorney Wydro? Commissioner David and then Commissioner Sanders.
The report says that the manager marked complainant's PIP as failed while he was on his second disability-related leave of absence. Is that accurate?
It is not, because he had not yet applied for a medical leave of absence. That was retroactively granted. So the manager marked it as failed, but he was still showing in the system as an active employee and had not logged into his computer for a month. So the manager finally just entered the decision, having heard nothing further from complainant. Retroactively, he was granted leave, yes.
I'm not sure why you can't answer that directly. Was it marked failed while he was on a disability-related leave of absence?
No.
No. So the investigator is wrong on that.
Correct.
Okay, thank you.
Sure. Yes. Thank you. I think I heard Attorney Fox say that once the pivot was issued, the complainant filed a complaint and made an allegation. The issuance of that pivot was discriminatory, that there was an investigation into those allegations, and that ultimately your client determined that there was no evidence to support his allegation. I also heard Attorney Fox say that to date, there hasn't been documentation of the investigation itself produced in the course of the commission process. And so I'm curious, is there documentation of that underlying investigation into the complainant's concerns that the pivot process was discriminatory?
There is an internal investigation report that was prepared by the team that investigated, summarizing those interviews that occurred at the time of the investigation, yes.
And have those materials been produced in the course of this process to the investigator and to the complainant?
I don't believe that we received a request for information for that report, but it was not provided as an exhibit to our written response, no.
Okay. Can you go back over for me this discrepancy between the 5 weeks versus the 5 months time period in which the complainant had to complete this OP1 report?
Yes. So the confusion seems to be over the time that the pivot was opened, which was December 1st, and the time that the pivot plan was written and approved by HR, which was March. So there is a document that has the pivot plan entry notes on it that says December 1st. That also includes the later written pivot plan expectations and deadlines of April 20th on it. And it seems like that's been conflated to be the original pivot plan, which was not the case. And this is what the witnesses attempted to clarify during the conference, that pivot is never a 4-month-long plan. Pivot is meant to be completed within a month based on their current role and expectations. So the document includes the notes that were added in March about the expectations that were meant to be delivered in April. But there was not a document given to complainant in December ever stating he had 4 months to complete certain expectations. Instead, that document was delivered in March, giving him, I think it was about 5 weeks to complete those expectations. And there is usually a little bit of additional time. I understand 5 weeks and 30 days is not exact, but at the beginning of the pivot plan, they have a meeting, and then there's a set amount of time where the employee has a time frame window to decide whether they want to try to meet the pivot plan or resign with severance. So there's a little bit of extra time after that meeting for that process.
And is that time frame consistent sort of among all employees who are similarly situated, or is that timeline customized depending upon what the nature of the concerns are? Give us more information about that.
Sure. So the HR witness spoke about this during the conference and explained that it's supposed to be no more than around 30 days, but certainly that exact date might be slightly flexible depending on what exactly the project is or what the team is working on at the time. But it's supposed to be around 30 days. So it certainly shouldn't be less time than that, but it's not going to be extended beyond that either.
Is that irrespective of the volume of concerns? I think I heard Attorney Fox say, you know, the concerns required the complainant to address, you know, sort of prepare a voluminous report on top of his day-to-day job responsibilities. And so I think I hear you say that it's generally 30 days, irrespective of how much the employee would have to do and produce in that time frame. Is that correct?
Yes and no. The pivot is not meant to add additional responsibilities to their plate. The OP1, Amazon disputes complainant's assertion that that was not a typical requirement of his role. That is Amazon's position, is that it was a typical requirement of his role. It was a known requirement of his role as a manager on the team, because it's a strategic position. And so that OP1 document is an annual document submitted to management in the springtime to strategize when looking back over the past year of metrics, how to improve the team's metrics. And I'm like very high level summary of what that is. So the pivot plan is not meant to add additional responsibilities, but instead to say, okay, here is what the person is working on right now over the next 30 days. And then to specify, here's what we're expecting you to deliver within 30 days. And if it doesn't meet these expectations, you'll have been determined to have failed the pivot plan.
Okay, thank you.
Sure.
Any other commissioner questions for Attorney Weigel? Seeing none, Attorney Fox, you have 1 minute and 5 seconds.
Okay, just a couple of things. Amazon, in its own response to the commission, said that on December 1, 2023, a pivot entry was created for the complainant with a deadline of April 20th, 2024 to complete the list of deliverables. That's what they said. Now they're saying something different. This involved, just to give you an idea, it involved him having to engage and set up meetings with 29 different stakeholders. And during the 5-week period, that's, it's roughly 25 working days. That's a crunch. That is a huge crunch when you're talking about, different people's schedules. The document itself repeats multiple times. There's no error here. She's saying that the witnesses said at the IRC conference something different. The entry creation is December 1, 2023. And then each of the 5 different expectations on the pivot reflect the April 20th, 2024 deadline. And that's my time. Bye.
Commissioner questions for Attorney Fox? Thank you.
Thank you.
Next, we'll hear from Angela Morse, the investigator assigned to this case.
Hi, I'm Angela Morse. I was the investigator assigned to this case. I know a lot of discrepancies were highlighted, so I'm certainly willing to answer any questions that I can about this case.
Commissioner questions for the investigator? Commissioner David.
Angela, is there a factual dispute here about your sentence in the last paragraph is that before the recommendation is that the manager marked the complaint as failed while he was on his second disability related leave of absence? You stand by that?
Yeah. Oh, thanks. That's inaccurate. On June 13th, complainant sent his manager an email saying that he needed to enter inpatient psychiatric program. He went out on leave to enter that program the next day, June 14th. While he didn't return till, I believe it was July 16th. And while he was not working and, addressing the mental health issues, he was alerted that he failed his PIP. So to me, that seems pretty clear. Whether or not Amazon had, formally designated that he was on a medical leave at that time, that's another story. But the fact of the matter is he was not at work at an inpatient psychiatric program during that time.
And was that leave, that hospitalization or program, psychiatric program, was that the one that he said, I'll be out of touch and the only way to get a hold of me is?
Exactly. Yep.
Yeah. Okay.
And that email was provided to me too, so I did see that.
Thank you.
Just following up very quickly on that, Investigator Morse. So I understand it. In other words, Amazon, the entity, because the complainant communicated with his managers, right, about his need for leave and the nature of that leave. Amazon was on notice, correct, at that point, even if, for example, you know, the HR team, right, that centralized team working through the pivot system, even if they weren't on notice, his immediate management team was. Is that a fair characterization?
Correct. And it didn't seem like there was any issue designating that time period where he was seeking this treatment as medical leave because it was retroactively, given to him after he returned.
Right. I'm thinking specifically about Attorney Fox's commentary or assertion during her presentation that, he came back to work kind of in the nick of time, right? Because seemingly Amazon was about ready to terminate him, even though, right, he was on a medical leave. Did I understand that correctly?
As far as when he returned, there was logs about when he logged onto his computer to work.
Sure.
So I don't think it was a situation where he was trying to time it in any certain way.
Thank you.
Any other commissioner questions for the investigator? Seeing none, thank you, Angela. Heard from the parties and the investigator, we'd be looking for a motion. There are two proposed findings.
I would, that we accept the investigator's report that there are reasonable grounds to believe that Amazon discriminated against Danny Brubaker on the basis of disability, and there are reasonable grounds to believe that Amazon retaliated against Danny Brubaker for engaging in this protected activity, and that conciliation should be attempted in accordance with 5 MRS.
Second.
James. All right, moved and seconded. Any discussion?
Yeah, I just think that the complainant is before the very compelling case. I can see how this would unfold, and the timeline here I think is troubling, compelling. So I think it's pretty it's a relatively easy case today.
Notwithstanding the corporate jargon.
Yeah.
Notwithstanding that
we can sort of parse the
Yeah.
corporate and get to the meat of the things.
The crux of the matter is our investigators' conclusion that they didn't show a non-retaliatory reason, leaving us with the fact that this has been a long coming retaliation over a period of time. And that's sufficient to justify a conclusion of unlawful discrimination.
Extenuation.
Further discussion? Being none, the motion is to find reasonable grounds on both findings. If you're in agreement, you will vote yes. Commissioner David?
Yes.
Commissioner O'Brien?
Yes.
Commissioner Walker?
Yes.
Commissioner Douglas?
Yes.
Commissioner Sanders?
Yes.
Okay. So the findings are reasonable grounds. The commission will send a letter to the parties and council confirming the results of the hearing and next steps for conciliation. Should we take 5?
Sure, you want to pass out
here?
the
Right.
We'll be in recess for 5 minutes, and then we have 2 more cases. And
Megan, come back. Thanks.
Oh, the penultimate case is page 25, 335 A and B, a housing case, Stephen Gregory, and Megan Barter versus Leonard Warren. And the recommendation is for a finding of no reasonable grounds on one count, and therefore we would hear from complainant.
Good afternoon, Mr. Gregory. You have
Good
10 minutes.
afternoon.
Do you want to reserve any of your time?
I'll reserve whatever time I don't end up using, please.
Okay, whenever you're ready, go ahead.
Perfect. Good afternoon, commissioners. My name is Stephen Gregory, and I want to thank you first for giving me the opportunity to present our side of the housing dispute that we found ourselves in at 17 Cherry Street in Millinocket. In my allotted time, I intend to lay out a timeline of events and to outline my reasons why I believe that the investigator's report of no reasonable grounds is incorrect and why the commission should find that we have established a prima facie case and that there are reasonable grounds for discrimination. My partner Megan Barter and I began our lease agreement for the apartment at 17A Cherry Street on May 15th, 2025. We slowly moved our belongings from our previous apartment to this one and commenced full tenancy beginning on June 1st, 2025. The first major incident relating to Megan's PTSD episodes and outbursts happened on June 21st, 2025. That evening, during a PTSD episode, Megan was yelling and being loud, which frightened the neighbors. The neighbors on this day took 2 precautions to ensure both their safety and ours. They called for a police wellness check, and one of our neighbors came over to make sure that everything was okay. When he came over to do so, Megan and I explained to him that she was having a PTSD episode and that we were on the tail end of it and that she was calming down. As I was explaining this to him, a couple of police cars had arrived to perform a wellness check on Megan. As they did so, Megan explained to the female officer that showed up what had happened, disclosing her PTSD and telling them that she was calming down and that all was okay. They and the neighbor left without further incident. The second major incident occurred 1 month later on July 21st, 2025. This incident is the main incident that supports my stance of objection to the investigator's report. On this particular day, in mid-afternoon, Megan had another PTSD episode. In this particular episode, I found myself to be very overwhelmed and needed to take some space to clear my head. When I did this, Megan proceeded to make an attempt on her life through attempting to overdose on her prescription medication. When I returned to the apartment, I found her conscious in the bathtub, where she had told me what she had done while holding a knife and showing narrow gashes on her arms and legs. The empty prescription bottles were scattered on the floor. She complained of not being able to breathe well, and this prompted me to call for EMS services to transport her to Millinocket Regional Hospital. As the ambulance was taking her away and I was attempting to follow them to the hospital, I was approached by the respondent, Callie Warren, along with our next-door neighbor. They expressed frustration and anger at the presence of both police and EMS at the apartment, and I informed them that Megan was having a mental health crisis and that she had made an attempt on her life. Regarding this particular incident, while I had not explicitly stated Megan's diagnosis of PTSD, I argue that the presence of emergency medical transport for a medical health crisis provides enough sufficient constructive knowledge where a reasonable person reasonably should have known that a disability was present, especially since this wasn't the first time that something like this had happened at Cherry Street. My lack of confrontational engagement, nor my lack of hostility with Megan, should also serve as constructive knowledge that these episodes were disability symptoms and not simply a couple's argument. On the night of August 20th, Megan was having another PTSD episode, which involved crying in the shower. The neighbors proceeded to bang loudly on the walls, which only escalated things further. Callie Warren came to our front door and again expressed frustration at the volume. In this interaction, I told her that Megan had a documented disability and that she had an appointment with her psychiatrist the following day to obtain the medical documentation. This is an interaction that Callie corroborated in her interview with the investigator. This took place prior to us receiving the notice to quit the following day, again showing that the respondents had prior knowledge that Megan had a disability that was causing these episodes before issuing us a notice to quit. The following day, Megan had an appointment with her psychiatrist at 7:30 that morning. At this appointment, she requested the medical documentation to support her disabilities and to support our cat's status as an emotional support animal. Early that same afternoon, respondent Leonard Warren knocked on our door and issued us a notice to quit. We could not yet provide the medical documentation to him there because we had received it later that day. The requests for accommodations and medical documentation were both provided to the respondents via email and in-person delivery when their office was next open, the following Monday, August 25th, 2025. When I delivered the documentation in person, I spoke to the respondents briefly, which was the recording that I provided to the MHRC. When I requested Megan's accommodations. Our request involved communications needing to be in writing because the aggressive confrontation from the landlord's neighbors and police made her PTSD episodes worse instead of better. That these episodes not be considered as grounds for eviction and that our cat be allowed to be an emotional support animal and for our pet fee to be returned to us. When I met with the respondents to request these accommodations, their attempt to mitigate the situation was to offer to help us find more expensive housing and for us to still move out. When I explained to When I explained to them that this would not work both for the financial burden it would cause by having more expensive housing that we could not afford, as well as a physical burden, having Megan moving so soon after our initial move, dealing with physical ailments such as herniated disc, which have gotten worse since we've had to move out of the apartment so soon. Once I told them that these would be the reasons why their suggestion would not work, they completely abandoned the interactive process and instead stood firm on threatening court. They did not give us the opportunity to suggest modifications to the apartment or to further discuss any solution to the issue that didn't lead to eviction. The MHRC complaint is the sole reason why the eviction process did not proceed. Had it not been for this, we would have had to contest the eviction in court. On September 13th, 2025, Megan had a PTSD episode which led to a confrontation with our next door neighbor. To combat the loud nature of the episode, our neighbor banged on the wall and screamed back. This tense back and forth escalated to him coming to our front door and being aggressive and confrontational and causing a scene. During this tense exchange, he said loudly, "She needs to shut the F up or I'll make her shut up." We took this as a threat and I called the police. I explained the situation to the police that answered the call and they were understanding of Megan's PTSD. There weren't any charges filed or any further actions taken with this call aside from the police speaking with both Trevor and I. Because of the tense and stressful living situation, we still did seek alternative housing, which we did eventually find. We moved out of 17 Cherry Street fully on November 15th, 2025. On December 3rd, 2025, I asked Callie about the status of our security deposit. She told me she would check on the status and give me an update. I did not hear any update until December 17th, 2025, 32 days after we moved out. They provided our pet fee and security deposit back to us, albeit with very clearly passive-aggressive comments about the pet fee being a non-refundable fee, non being emphasized and underlined. The security deposit had $160 removed due to damages to the apartment, but because of the return of the deposit and or an itemized list of deductions not being provided to us within 30 days, I requested the additional $160 to be returned to us. Callie was extremely resistant to doing this at first. And when I proceeded to threaten small claims court, we received the $160 via check in the mail. On the envelope, they had written, "Congratulations, you just sold your soul for $160. These passive-aggressive comments show a clear lack of remorse towards their discrimination against Megan's disabilities and rights and shows that they were acting in bad faith. The investigator's report lists that in order to establish a prima facie case for disability discrimination, we need to show that Megan has a physical or mental disability as defined by the MHRA, shown through the medical documentation that we provided to the MHRC and to the respondents, that respondents knew or reasonably should have known of Megan's disability. Respondents were informed of Megan's disability on numerous occasions through word of mouth and the subsequent medical documentation, but also had the onus of reasonably should have known through the aforementioned EMS presence for a mental health crisis. Number 3, complainants requested a particular accommodation, which was expressed in our letter to the respondents and through my direct meeting with them in the provided video. Number 4, the requested accommodation is necessary to afford complainants an equal opportunity to use and enjoy the housing. The otherwise attempted eviction would have forced us out of housing due to a symptom of a documented disability. The requested accommodation is reasonable on its face, meaning it is both efficacious and proportional to the cost to implement it, and respondents refused to make the requested accommodation. The interactive process was completely abandoned by the respondents in this case, and they did not act in good faith to try to mitigate the situation. For these reasons, I believe that we have established a prima facie case of housing disability discrimination, and I ask that the commission find reasonable grounds that Megan was discriminated against. Thank you.
There are questions for Mr. Gregson.
Yes.
Commissioner David?
Mr. Gregory, I'm not unsympathetic to the situation or the disabilities. Certainly a difficult situation for you both to deal with. Do you agree that the behaviors that are the result of that disability interfered with the tenant's ability to enjoy their residence?
So the nature of these particular episodes are not threatening in nature. They are loud and during reasonable hours. In the process of trying to mitigate these particular episodes, Megan has had to meet with her psychiatrist more often and has been on increased dosages of both anxiety medication, antidepressant medication, and sleeping medication in order to try to lessen the overall episodes themselves. So she's essentially doing what she can in order to make sure that those episodes themselves don't happen. And there was also an incident where, in order to not have the loud episodes, she proceeded to self-harm, hitting herself very aggressively in order to not have loud episodes. And so while I could see that the volume could potentially do that, the respondents did not allow us to even suggest modifications that we could have made, and instead said, we'll see you in court. That's what courts are for. Yeah.
Your suggested accommodation was structural modifications to the apartments?
Yeah, so if we were, if the respondents had given us the ability to suggest modifications, we would have suggested like soundproofing at our own cost, or providing like sound machines to the neighbors to try to mitigate some of the sound, or looking into various other things. Sorry, did you say something?
That never happened? Those suggestions were never made?
No. So when I met with the respondents, their suggestion had been to have to help us find more expensive housing. That was literally part of what they said to me, was that it wouldn't be the same cost, it would cost more. And when I told them that that wouldn't work because of both the financial burden and the physical burden with Megan's physical disabilities as well, they completely abandoned the interactive process, wouldn't even talk to me about any other part of it, wouldn't give me the opportunities to suggest any of those modifications, and instead just said, that's what courts are for, we'll see you in court.
Any other commissioner questions for Mr. Gregory? Seeing none, Renee Snow, are you here for the respondents? You're muted.
I am here for the respondents. Good afternoon, commissioners.
You
And
have,
I would reserve whatever time I don't use.
okay, whenever you're ready.
This case involves a small apartment building in Millinocket. It's a 2-unit apartment building. The 2 units share a common wall. Mr. Gregory and Ms. Barter occupied 1 unit. The neighbors next door occupied the other unit, and their children's bedroom, and these are young children, shared that common wall. When we are asking that the commission adopt the findings of the investigator and find that there are no reasonable grounds to believe that either of the respondents discriminated against either of the complainants on the basis of disability. And the investigator looked at 2 different areas, one being a potential discrimination on the basis of denial of reasonable accommodation. The complainants in this case, the only accommodation that they actually offered to my clients were that basically Ms. Barter be allowed to continue with her outbursts without any consequences going forward, and that all further communications would have to be in writing, and of course that there would be no eviction and they'd be allowed to continue there. My clients rejected that because it was simply an issue of the neighbors next door were already complaining, threatening to move out. And if they did move out, any potential tenants in that neighboring unit, as long as the complainants were there, would need to be informed of what was going on, the potentiality of these outbursts. And they believed that it would be difficult, if not impossible, to rent the other apartment, the other unit in this building, if this continued. That is the reason that they suggested that they could offer other units that they have available, either a single family home or a mobile home. Yes, they were slightly more rent per month, but my clients felt that it would be better off. Ms. Barter could have the outbursts. Nobody's going to hear it except for Mr. Gregory if he's home under those circumstances. And the investigator found that the accommodations suggested by the complainants were unreasonable because it would place an undue financial burden. As Mr. Gregory indicated, they never even raised the issue of soundproofing the walls or things of that nature. Although that would certainly, I agree with the investigator, that would be a modification, not an accommodation. So, and that would be an expense that under the statute, the complainants would have to bear. Now, as far as the discussions about these accommodations and who said, see you in court, my clients have maintained that it was always Mr. Gregory that said, see you in court. So there is a factual dispute on that one issue. As far as the eviction is concerned, Mr. Gregory is correct. The eviction was served on the 22nd of August, and it never proceeded further than that. And there was no forcible entry and detainer action begun or anything of that nature. They were not eventually evicted from the property. They gave notice that they were moving out, and they did move out in mid-November, some 3 months after the notice to quit was served. Now, as far as when my clients, in order to prove that there was a disability discrimination in the eviction process, the complainants have the burden of proving that my clients were aware of the disability before the eviction notice was served. The investigator found that in July, my clients were not given notice by Mr. Gregory during that incident when I believe that was the incident when the EMS was called and they had to take Ms. Barter to the hospital. And the complainants argue that that's constructive notice of a disability, a mental disability or physical disability. But the statute says that under the definition of a disability, it has to have an expected duration of 6 months. Yes, perhaps my clients were aware that there was an incident that required Ms. Barter to be hospitalized or taken to the emergency room, but there are numerous mental issues, problems that they can result in a trip to the emergency room in an ambulance, but it doesn't mean it's going to last for 6 months or longer and be a disability. So no, that didn't happen. In August, the investigator found that Mr. Gregory simply told Ms. Warren that his partner was having difficulty dealing with a loss or death in the family. Again, that's not notification of a disability under the statute. That doesn't come until August 25th, when the meeting occurs between all of the parties and when Mr. Gregory and Ms. Barter present the letters from her treating physicians asking that they not be evicted, that notifying them of what her diagnoses were, and asking that the cat be considered a support animal. And it's important to note that they when they moved in, none of this was disclosed to my clients. The complainants voluntarily, there's a $250 standard pet fee. They voluntarily paid that. They never mentioned that the cat was a support animal. That never came up until after the eviction notice was served. Yes, that deposit was returned. And eventually all of the security deposit was returned, although the last $160 was after the 30 days. So in this case, the investigator, as far as the eviction is concerned, said, they haven't proved a prima facie case because they can't prove this for notice. But even if they did, my clients had a legitimate reason to serve the eviction notice, and that is because it was interfering with the enjoyment of the peaceable possession of the neighbors in the adjoining apartment. I mean, the evidence shows that these outbursts didn't occur at reasonable times, as Mr. Gregory said. Some were unreasonable times because the neighbors' children were in their bedrooms and they'd be crying. The mother would have to comfort them, and it really upset the mother. So there was a legitimate reason to serve the eviction notice. And again, we ask that you adopt the investigators' decision. Thank you.
Commissioner questions for Attorney Snow? Commissioner Davis.
I thought I heard you just say that the second $160 was returned. Am I correct? Was that a double damages thing because it was more than 3 days?
No, it was just what remained of the original security deposit that hadn't been returned earlier. I believe my clients were intending to keep that to cover some cost. They did not give the proper notice, so they returned the remaining 160.
Any other commissioner questions? None. We'll go back to Mr. Gregory. You have 55 seconds.
Perfect, thank you. I just want to cover a couple of things. So Attorney Snow had mentioned regarding our requested accommodations. So the initial request for accommodations letter had listed the ones that he had laid out. And then in giving the letter to the respondents, and they had suggested more expensive housing. Ultimately, the onus is to continue the interactive process, hence the interactive. And once I had explained to them why the interactive or why their suggestion wouldn't work, they completely abandoned it. Leads me to my second point, talking about the factual basis of who had suggested court. So I had submitted the entire conversation that I had with the respondents in a 10-minute recording, of which court was mentioned 10 times, 8 of them by respondent Leonard Warren and 2 of them by me asking clarifying questions. So in terms of that's verifiable that it was not me. Thank you.
That's your time. Commissioner, questions for Mr. Gregory? Okay. Being none, I will return to Attorney Snow. You have 1 minute and 3 seconds.
I don't believe I have anything additional to add to what I stated previously. If there are any questions, I'd be glad to address them.
Commissioner, questions for Attorney Snow? Being none, thank you both. Next, we'll hear from Uber Leva, the investigator assigned to this case.
Good afternoon, commissioners. I don't have anything to add that wasn't in my report. The parties have laid out their cases to you as they did to me, and everything that I believed was important to my decision has been included in my report. So I'm happy to answer any questions if you have them.
Questions for the investigator? Commissioner David?
Would it have made a significant difference to you if they had known about the disability when they filed the eviction?
Those weren't the facts in this case, so I can't say if that would just, had those been the facts, maybe the decision would have been different, but given what was in front of me when I wrote this report, I found the way that I did.
Was there any indication of the frequency of the behaviors that would have crossed over to the tenant, you know, in terms of being loud or threatening, or either to herself or others? How often did it happen?
Yeah, so in my report, I did mention that between June 2025 and August of 2025, there were approximately 10 outbursts. So in that 8-week period, there were 10 that were very loud and that the neighbors could hear. And then there were a few outbursts that occurred after August 2025 as well. One that was noted and mentioned to the respondents by the neighbors in September of 2025.
Thank you.
Any other commissioner questions for Nooper? Seeing none, thank you, Nooper.
Thank you.
We've heard from the parties and the investigator. We're looking for a motion on the one proposed item.
I move that we accept the investigator's report as written, that there are no reasonable grounds to believe that Leonard Warren, Allie Warren, discriminated against Steve Gregory and or Megan Berger on the basis of disability, and that the complaint should be dismissed in accordance with 5 MRS section 4612 subsection 2.
Okay. Moved and seconded. Any discussion?
I would just say to Mr. Gregory that I appreciate your position. I do. And I think that this is a difficult case for everyone, right? I mean, you want a place to live and you're trying to advocate for Ms. Barter, which I do appreciate very much. And the landlord's trying to keep his, his other tenants, under difficult circumstances. So I do think it's an unfortunate case. And I just wanted to highlight
that. I agree, Mr. Gregory, with Commissioner Douglas's comment. I mean, it has the feel that there was an interaction, there was a process, there was a discussion about what can we do about this. but the landlord is not responsible for the unfortunateness of the condition of your partner. And your presentation was that they have to make it right because she's disabled. I didn't find that to be an unlawful discriminatory intent.
Any further discussion? Seeing none, the motion is to find no reasonable grounds. If you are in agreement, you will vote yes. Commissioner David?
Yes.
Commissioner O'Brien?
Yes.
Commissioner Walker?
Yes.
Commissioner Douglas?
Yes.
Commissioner Sanders?
Yes.
And the last.
I know, the findings are no reasonable ground. The commission will send a letter to the parties and council confirming the results of the hearing.
And the last case,
Thank you.
the last case for hearing today is a housing case 250488 to Ralph Sprague versus Ricky Deloge. And the suggested, the recommended finding is for a finding of no reasonable grounds. You would hear from complainant first.
I do not believe the complainant is here. Mr. Deloge is here and has been with us since this morning. He did let me know that he heard from Mr. Sprague that he has an attorney and he shouldn't, he wasn't planning to come and Mr. Deloge didn't need to come. Mr. Deloge decided to come anyway, just in case, which he said was probably wise. But it does look like Mr. Sprague is not here. So as with the prior case, when it's a recommended finding of no reasonable grounds and the complainant does not appear, we generally adopt the finding of the investigator's report. Unless you would like to hear from the investigator or Mr. Deloge or both.
I don't think that's necessary.
I don't think it's necessary reading the facts.
Nobody would probably want that.
Deloge would like to go home. Yeah. Right, so do I have a motion?
Right.
One proposed finding.
Okay, just like, I make a motion, we accept the report. If there are no reasonable grounds to believe that Ricky Deloge discriminated against Randolph Sprague Jr. based on disability, and the complaint should be dismissed in accordance with 5 MHRC.
Second.
Discussion? None, the motion is to find no reasonable ground. If you are in agreement, you will vote yes. Commissioner David?
Yes.
Commissioner O'Brien?
Yes.
Commissioner Douglas?
Yes.
Walker?
Yes.
Commissioner Sanders?
Yes.
Okay. So we will send a letter, but that is the end of the case of the commission, and you'll get a closure letter from us probably sometime this week.
I've only got one question.
Sure.
He's makes a habit of doing this. And we have a family gathering and we'd like to get him out of that. So we're not gonna get you guys, if he gets you guys involved again, you guys are gonna go back into this.
We don't generally take prior cases into account, but we are aware of them when another complaint is filed.
Would you accept it back if he complains again?
Not on these same facts.
Okay, that's all it's, yeah.
Yeah.
It was only.
It would have to be something new.
Yeah.
These claims are done now.
But it was all about a driveway and I'm all about land, collecting my money. That's all, that's what this is all about. He still hasn't paid in over 2 years. So I gotta need to get him out of that.
Understand. Yeah, thank you for hanging with us for the entire day.
Well, I learned something.
You don't want to come back.
You don't want to do this again.
I did make a call last week to see what time you wanted me to get here, but nobody got back to me.
Well, we can't tell you what time because sometimes, as you said, like I thought we were going to be here until 4 today, but then somebody else didn't show up and one of the other cases went fast. And so it's very hard to tell somebody when you're going to be here.
Yeah, Snow was there. That's pretty important. He's one of my longtime buddies.
Oh, well, I'm glad you got to see each other. Have a good day. Take care.
He knows I was here though. Okay, thank you.
All right, thank you. Okay,
So,
a motion.
Pursuant to the revised statutes 4056E, we go into an executive session to consult with our attorney pending pending and contemplated litigation and the rights and duties of the commission.
Okay. Any discussion? We're not done yet.
Seeing none, if you are in agreement, you will vote yes. Commissioner David?
Yes.
Commissioner O'Brien?
Yes.
Commissioner Walker?
Yes.
Commissioner Douglas?
Yes.
Commissioner Sanders?
Yes.
Okay. Okay. So I need a motion to not litigate E240025 A and B Markart versus Midwest Veterinary Partners et al.
Second.
Discussion? Seeing none, Commissioner David?
Yes.
Commissioner O'Brien? Yes. Commissioner Walker?
Yes.
Commissioner Douglas?
Yes.
Commissioner Sanders? Yes. And I need a motion to approve the settlement and allow us to sign an agreement in H240273 A and B, Best and V Rogers et al.
So moved.
Discussion? Commissioner David?
Yes.
Commissioner O'Brien?
Yes.
Commissioner Walker?
Yes.
Commissioner Douglas?
Yes.
Commissioner Sanders?
Yes.
Okay. Good meeting, everybody.
Good morning, y'all.
See you in June. Safe travels.
Well, you want all this stuff? Sure. And I